days, except for the fact that Judge St. John's going to do my calendar tomorrow so we can start super early. Another judge is going to do my calendar, okay? And then, and we're going to hear from probably 4 witnesses today. The 4th one is going to be on Zoom. So we're going to take a break between the 3rd one and the 4th one to make sure we have Zoom ready, okay? And I don't think there's anything else that we went over. Is there anything else that Mr. Nealy needs to know? All right. Again, we are going to hand out the preliminary instructions so that they can read along while I'm reading them, and then I'll collect them. Then I'll, or the bailiffs will give them their notepads, and then I'll go over note-taking from the standard jury instructions. Okay, and then we'll start with openings right after that. Okay. All right, so are we ready for the jury? Anyone who is not ready for the jury? Okay, so let's bring the jurors in. Just swear them in normally. That's all. Just swear them in. That it's a normal.
No.
Case. Right. All right, members of the jury, welcome back. What's going to happen at this point is I'm going to read the preliminary instructions to you, and I'm pretty sure I told this to the Monday people, but maybe I didn't say it yesterday, is that I'm going to give everyone a copy of those preliminary instructions, and I think most people process information better by reading along while I read them. And then I will collect them, or the bailiff will collect them after I read them. If you're the kind of person who processes information better just by listening, that's fine. I think most people process information better if they can read along while I am reading. Okay? And then we'll collect them. Then I'll go over note taking. We'll give you some notepads to take notes if you want to, and I'll go over that instruction. Then we'll have opening statements. The plan, as you know, plans can change, is to put on 4 fairly quick witnesses today. At the end of the third one, we're going to have to take a break to set up Zoom, because the fourth one's going to be on Zoom, and then we'll end for the day. All right, everybody good with that? All right. All right, go ahead and hand them out. Everybody has one? Yes, Your Honor. Very good. Members of the jury, the defendant entered a plea of guilty to 3 counts of first-degree murder in this case. The only issue before you is to determine the appropriate penalty. The penalty for each of these crimes is either life in prison without the possibility of parole or the death penalty. Before proceeding further, it will be helpful if you understand how this proceeding will be conducted. The attorneys will have an opportunity, if they wish, to make an opening statement. The opening statement gives the attorneys a chance to tell you what evidence they believe will be presented during the penalty phase of this trial. What the lawyers say during opening statements is not evidence, and you are not to consider it as such. After the attorneys have had the opportunity to present their opening statements, the state and the defendant may present evidence. Witnesses may be called to testify under oath. If so, they will be examined and may be cross-examined by the attorneys. Documents and other exhibits also may be produced as evidence. This evidence is presented for you to determine whether the state proved, beyond a reasonable doubt, the existence of the alleged aggravating factors. If so, you must weigh whether the proven aggravating factors are sufficient and whether the aggravating factors outweigh any mitigating circumstances the defendant proves by the greater weight of the evidence. Finally, you will decide whether the defendant should be sentenced to life in prison without the possibility of parole or to death. At the conclusion of the evidence and after argument of counsel, you will be instructed on the law that will guide your deliberations. An aggravating factor is the only circumstance recognized by Florida law that could result in a defendant receiving the death penalty. An aggravating factor increases the gravity of the crime or the harm to the victim beyond the harm inherent in every first-degree murder. You must unanimously agree that an aggravating factor has been proven beyond a reasonable doubt before it may be considered by you in arriving at your sentencing decision. The aggravating factors alleged by the state in this case are: number 1, Shelby Nealy was previously or contemporaneously convicted of another capital felony or a felony involving the use of violence to another person. The crime of murder in the first degree is a capital felony. The crime of manslaughter is a felony involving the use of violence to another person. Number 2, the first degree murder was committed for the purpose of avoiding or preventing a lawful arrest. Number 3, the first degree murder was especially heinous, atrocious, or cruel. Heinous means extremely wicked or shockingly evil. Atrocious means outrageously wicked and vile. Cruel means designed to inflict a high degree of pain with utter indifference to, or even enjoyment of, the suffering of others. The kind of crime intended to be included as especially heinous, atrocious, or cruel is one accompanied by additional acts that show that the crime was conscienceless or pitiless and was unnecessarily torturous to Laura Ivancic, Nicholas Ivancic, and Richard Ivancic. And number 4, the first degree murder was committed in a cold, calculated, and premeditated manner without any pretense of moral or legal justification. Cold means the murder was the product of calm and cool reflection. Calculated means having a careful plan or prearranged design to commit murder. A killing is premeditated if it occurs after the defendant consciously decides to kill. The decision must be present in the mind at the time of the killing. The law does not fix the exact period of time that must pass between the formation of the premeditated intent to kill and the killing. That period of time must be long enough to allow reflection by the defendant. The premeditated intent to kill must be formed before the killing. However, in order for this aggravating factor to apply, a heightened level of premeditation demonstrated by a substantial period of reflection is required. A pretense of moral or legal justification is any claim of justification or excuse that, although insufficient to reduce the degree of the murder, nevertheless rebuts the otherwise cold, calculated, or premeditated nature of the murder. Once the state has presented evidence of the existence of aggravating factors, victim impact evidence may be presented. Such evidence is only presented to demonstrate the victim's uniqueness as an individual and the loss to the community by the victim's death. However, victim impact evidence must not be considered by you as an aggravating factor. A mitigating circumstance can be anything that might indicate the death penalty is not appropriate for the defendant. It is not limited to the facts surrounding the crime. In other words, a mitigating circumstance may include any aspect of the defendant's character, background, or life, or any circumstance of the offense that may indicate that the death penalty is not an appropriate sentence in this case. Whether a mitigating circumstance has been proven is an individual judgment by each juror. A mitigating circumstance need not be proven beyond a reasonable doubt, but must be proven by the greater weight of the evidence. After the evidence has been presented, the attorneys will have the opportunity to make their closing arguments. Following the closing arguments by the attorneys, the court will instruct you on the law. After the final instructions are given, you will begin your deliberations. You should not form any definite or fixed opinion until you have heard all the evidence, the argument of the lawyers, and my instructions on the law. Until that time, you should not discuss the case among yourselves. Your decision must be based solely on the evidence or lack of evidence and the law. During the penalty phase, the court may take recesses, and you will be permitted to separate and go about your personal affairs. During these recesses, you must not discuss the case with anyone, nor permit anyone to say anything to you or in your presence about the case. If anyone attempts to say anything to you or in your presence about this case, tell him or her that you are on the jury and ask the person to stop. If he or she persists, leave that person at once and immediately report the matter to the bailiff, who will advise me. All cell phones, computers, tablets, or other types of electronic devices must be turned off while you're in the courtroom. Turned off means that the phone or other electronic device is actually off and not in a silent or vibrating mode. You may use these devices during recesses, but even then, you may not use your cell phone or electronic device to find out any information about the case or communicate with anyone about the case or the people involved in the case. Do not take photographs, video recordings, or audio recordings of the proceedings or of your fellow jurors. After each recess, please double check to make sure your cell phone or electronic device is turned off. At the end of the case, while you are deliberating, you must not communicate with anyone outside the jury room. You cannot have in the jury room any cell phones, computers, or other electronic devices. If someone needs to contact you in an emergency, the court can receive messages and deliver them to you without delay. A contact phone number will be provided to you. The penalty phase must be tried by you only on the evidence presented in your presence and in the presence of the defendant, the attorneys, and the judge. Jurors must not conduct any investigation of their own. This includes reading newspapers, watching television, or using a computer, cell phone, the internet, any electronic device, or any other means at all to get information related to this case or the people and places involved in this case. This applies whether you're in the courthouse, at home, or anywhere else. You must not visit places mentioned or use the internet to look at maps or pictures to see any place discussed during the penalty phase. Jurors must not have discussions of any sort with friends or family members about the case or the people and places involved. So do not let even the closest family members make comments to you or ask questions about the penalty phase. In this age of electronic communication, I want to stress again that just as you must not talk about this case face-to-face, you must not talk about this case by using an electronic device. You must not use phones, computers, or other electronic devices to communicate. Do not send or accept any messages related to this case or your jury service. Do not discuss this case or ask for advice by any means at all, including posting information on an internet website chat room, or blog. What are the reasons for these rules? These rules are imposed because jurors must decide the case without distraction and only on the evidence presented in the courtroom. If you investigate, research, or make inquiries on your own, I have no way to make sure that the information you obtain is proper for the case. The parties likewise have no opportunity to dispute or challenge the accuracy of what you find. This is contrary to our judicial system, which assures every party the right to ask questions about and challenge the evidence being considered against it, and to present argument with respect to that evidence. Any independent investigation by a juror unfairly and improperly prevents the parties from having the opportunity that our judicial system promises. Any juror who violates these restrictions jeopardizes the fairness of these proceedings, and a mistrial could result that would require the entire process to start over. A mistrial is a tremendous expense and inconvenience to the parties, the court, and the taxpayers. If you violate these rules, you may be held in contempt of court and face sanctions, such as serving time in jail, paying a fine, or both. In every criminal proceeding, a defendant has the absolute right to remain silent. From the exercise of a defendant's right to remain silent, a jury is not permitted to draw any inference regarding the existence of an aggravating factor or inappropriate sentence, and the fact that a defendant did not take the witness stand must not influence your sentencing decision in any manner whatsoever. The attorneys are trained in the rules of evidence and trial procedure, and it is their duty to make all objections they feel are proper. When an objection is made, you should not speculate on the reason why it is made. Likewise, when an objection is sustained or upheld by me, you must not speculate on what might have occurred had the objection not been sustained, nor what a witness might have said had the witness been permitted to answer. It may be necessary to confer with the attorneys out of your hearing to discuss matters that require consideration by me alone. It is impossible to predict when such a conference may be required or how long it will last. When such conferences occur, they will be conducted so as to consume as little of your time as is necessary. All right, so if Deputy Trong can collect the preliminary instructions, I'll put my copy in the court file. All right, now if we can hand out the notepads. We're keeping Deputy Trong busy. As I said on Monday, and I don't think I said on Tuesday, obviously at the very close of the case, I'm going to instruct you on the law. You'll also have a copy of those final instructions, and you'll be able to follow along as I read them. And you'll also be able to take them back into the jury room with you. So you'll have a copy of those. You'll also have all evidence introduced in the case as well. All right. Every one of you has a notepad and a pen. What I'd like you to do at this point is to write your name nice and big on the very first page. And then if you are going to take notes, start on page 2. That way we can see that it's your notepad, it's not anybody else's. And then no one will read your notes, because the purpose of this is for you to refresh your recollection if you want to take notes. It's not for other people to read your notes. All right, everybody ready? If you would like to take notes during the proceeding, you may do so. On the other hand, of course, you are not required to take notes if you do not want to. That will be left up to you individually. You have been provided with a notepad and a pen for use if you wish to take notes. Any notes that you take will be for your personal use. However, you should not take them with you from the courtroom. During recesses, just put your notepad down on your chair. If you want to take the pen with you, you can. Just don't forget to bring it back. After you have completed your deliberations, the bailiff will deliver your notes to me. I will give them to my judicial assistant. She will destroy them. That's one of her favorite jobs, especially compared to the other things that I give her. No one will ever read your notes. If you do take notes, do not get so involved in note-taking that you become distracted from the proceedings. Your notes should be used only as aids to your memory. Whether or not you take notes, you should rely on your memory of the evidence, and you should not be unduly influenced by the notes of other jurors. Notes are not entitled to any greater weight than each juror's memory of the evidence. All right, anyone have any questions before we begin with opening statements? All right, I'm going to see any hands. Ms. Raby, you may proceed with your opening statement.
3 weeks. 3 weeks. We are here today because between December 14th, 2018 and December 16th, 2018, this defendant, Shelby Nealy, murdered Richard Ivancic, Laura Ivancic, and Nicholas Ivancic so that he could avoid the consequences of his actions for what amounted to 3 more weeks. Thank you all for your time and attention thus far. I know it's been a long day, a long process, but opening statement is my opportunity to tell you what I expect the evidence to show. A summary of the story that is going to come, if you will. And the testimony and the evidence in this case is going to transport you outside of this courtroom and into the lives of, and the last days of Richard Ivancic, Laura Ivancic, and Nick Ivancic. The day before, or 2 days before, he was brutally murdered was Richard Ivancic's 71st birthday. You'll get to hear a little bit about Richard. He was an athlete in high school, married his high school sweetheart, and with her had 4 children. Richard, same name, Renee, Mike, and Mark. They lived in Ohio, and after a number of years, Richard and his first wife separated. Get to the mid-1980s, Richard would eventually meet and marry Laura Ivancic. Laura's 59 in December of 2018 when this defendant brutally murdered her. Laura and Richard had a passion for fostering children. Children who didn't have any other place to go, who needed love and care, if only for a little while. Nicholas and Jamie were the 2 children that, after fostering, they were able to adopt, not providing just a temporary refuge and temporary love and care. Instead, Richard and Laura were there to provide them with permanent love and care. Nicholas had been born in 1993, which means he was 25 years old when this defendant killed him. And Jamie had been born in 1997. So in Ohio, where all these people were living for a period of time, Nick, as he got older, teenage years, worked for a time at Burger King. And he becomes friends at Burger King with another employee there, this defendant. Through this friendship, the defendant meets Nick's sister, Jamie. They become romantic, the defendant and Jamie, and they marry. Early on in their relationship, which would have been roughly 2015 and 2016, they moved to South Florida, where Richard had moved, and lived with him for a time, but then they end up moving back to Ohio, where Laura had remained and was living because her mother was dying and she was staying to care for her mother. This defendant and Jamie have a child up in Ohio named, a little girl named Bella, who would have been roughly 3 in December of 2018, when the most relevant time period. So the defendant and Jamie live with Laura or other members of Laura's family for a little while up in Ohio. And then the defendant and Jamie end up moving back down to Florida and living again with Richard in Spring Hill, here, close to here in Hernando County. Jamie and the defendant and their child live there for a time in Hernando. Laura's mother does pass, and she moves down to Florida to be with Richard. So roughly mid to late 2017, this defendant and Jamie rent a house at 10930 Norwood Avenue in Port Richey, which is in Pasco County. So now they and their child are living there alone, and Jamie has a second child, a little boy who will end up being approximately 1 year old in December of 2018. By mid to late February of 2018, the residence at 10930 Norwood Avenue is abandoned. Family is gone. Jamie's phone's having problems, but Laura and Richard and others still communicate with Jamie via texting or social media. Time passes. Laura and Richard, who had been close with Jamie, living with her, regular part of her life, they keep communicating with her, or trying to communicate with her, and trying to see their daughter. Jamie's family is in Ohio, and they're in Texas. Finally, Jamie and her family, which would be this defendant and the 2 kids, are going to come to Florida to visit. So by now, Richard and Laura have moved to 1954 Juanita Way, which would have been, they moved there sometime in mid-2018, which is in the Little Mobile Home Park in the northernmost part of Tarpon Springs, here in Pinellas County. It's a 55-plus community, but Nick stays with them for the most part too. He lives there as well. And he'd been living with Richard for some time in Florida at the point where Richard had moved down here. So now Jamie and her family are coming to visit 1954 Juanita Way early to mid-December of 2018. They'll be there for Richard's birthday, the holidays, but at some point between December 2nd and December of 2018 and December 7th, so 2nd and 7th of 2018, Jamie's gray Hyundai vehicle arrives with this defendant, the 2 kids, but no Jamie. This defendant explains to them how Jamie couldn't make it because of work. She had to stay in Texas. They were also ducking collections investigators because they had abandoned the Norwood Avenue residence. So Jamie remained in Texas and didn't come. So the defendant and his 2 kids, remember about 3 and about 1, are staying with Richard, Laura, and Nick for at least a week, which brings us to December 14th of 2018. So we know on December 14th that Laura goes on a shopping trip. We know it takes her up to State Road 50 in Hernando County. She goes to a CVS, she goes to a Cracker Barrel, she goes to a bank, and then the last place that we know she goes is to a Walgreens on US 19 in Port Richey, which would be on the way back. And that's at 3:45 p.m. in her red 2013 Kia vehicle. So backing up just a bit, the day before, which would be December 13th of 2018, was Richard Ivancic's birthday. Richard, as I mentioned earlier, turned 71. And on that day, he spoke to people on the phone. In particular, his son, Richard, I'm going to call him Rich to distinguish, his son Rich, and that is the last time that anyone outside of the people staying at 1954 Juanita Way will hear from Richard. Because once you hear the evidence and put the pieces together, it will show that Laura goes on that shopping trip. And either during those hours shopping, as the evidence will suggest, or potentially, maybe on the 15th at a shopping, if she's shopping again, definitely no later than the 15th, that Nick is apparently not home as well, possibly working. So Richard is alone, 1954, Juanita Way, with this defendant and the two small children. And this defendant, all along, had been planning to murder everyone in that house. So while Richard is walking in the house, in the dining room area, towards the kitchen, this defendant, armed with a hammer, attacks him. Richard gets hit twice in the chest. A third blow hits him in the neck. And then he is struck multiple times in the head. Richard lies there horribly injured for some period of time as the defendant realizes he's not dead, and then comes back and attacks him more, inflicting injuries that will ultimately result in Richard's death. Richard gets hit in the head at least 7 times that can be detected. Because multiple blows are hard to tell. If you're hitting somebody in the same place over and over again, you can't necessarily distinguish it as multiple blows. But there's at least 7 blows to the head. In the nose, in the forehead, in the right eye, in the back of the head. So the defendant leaves Richard there on the floor and waits. He waits for Laura to return so that he can bash Laura's skull in as well. So Laura, as I told you before, we know was at Walgreens in Port Richey at 3:45 p.m. on December 14th, which was a Friday. Given travel time, she's alive until at least 4 p.m. on the 14th. Give or take a few minutes. So she walks into her house, no idea that Richard is lying with his head bashed in, dying on the floor. And as she goes to enter the kitchen, the defendant begins bashing her head in with a hammer, striking her at least 5 times in the back of the head. So that leaves Nick. While Nick is away, the defendant begins to hide the evidence of his horrible crimes. Both Laura and Richard are apparently incapacitated on or very near to carpets lying on the floor in the respective rooms that they are in. So the defendant uses the carpet to roll up Laura, drag her down the hallway of this mobile home to the end door, which is the master bedroom, and into the connected master bathroom. He then rolls up Richard in the carpet, drags him down the hall into the master bedroom, and closes the door. He then mops up the floor to ensure that Nick will not suspect the violent fate that his parents have suffered and the violent fate that this defendant has in store for Nick himself. Nick will eventually return home. It is not entirely clear when, sometime between the late afternoon, early evening of December 14th, possibly sometime on December 15th. But remember, Nick was a friend, a good friend of the defendant. They were close. They are close. So the defendant wants to hang out with Nick one last time before he bashes his head in with a hammer. They get pizza. They hang out. They watch TV. They smoke. Nick even leaves to get more marijuana at some point and comes back. At some point, they watch The Grinch. This goes on And some point between the early morning of December 15th and the early morning of December 16th, Nick is asleep on the couch in the living room, and this defendant is awake. So now it's time to finish what he traveled from Texas to do. The defendant gets the same hammer, comes up to Nick while he's sleeping, and begins bashing him in the head. Nick springs up, and is not quick, like the defendant will later claim he wanted it to be, and there are multiple blows, bashing Nick's forehead in, causing the injuries that will ultimately lead to his death. At least 3, but in the estimate of this defendant, at least 5 to 7 blows. Nick is similarly dragged from the living room on some type of blanket from the couch into his bedroom and left unceremoniously on the floor just inside the door. About 2.5 weeks pass. Christmas comes and goes. Laura's brother-in-law passes away. Richard, Laura, and Nick aren't discovered dead and rotting at 1954 Juanita Way until New Year's Day of 2019. Multiple family members had tried to contact them between December 14th of 2018 and New Year's of 2019. But as they later found out, this defendant had been answering some texts on Laura's phone as part of his plan in order to throw everybody off, which we did successfully for a time. But on January 1st of 2019, Richard's oldest son, Rich, has been trying to reach his father and has not been able to. He compares notes with other family members, and he's concerned, so he calls law enforcement to do a welfare check so that the law enforcement here can have contact and make sure the people at 1954 Juanita Way are okay. The people were not okay. So Officer Rondos with Tarpon Springs Police Department responds along with other law enforcement officers. It doesn't take long to suspect that this is not the typical welfare check call they get, and that something far more sinister is going on. And it will take more than just a knock on the front door and making contact. So upon arrival, they get there. There's an obvious hole dug in the front yard. It looks like a grave. Dirt piled up on one side. Walking around the mobile home, there are flies visible on the windows, on the inside. And there's the smell. Law enforcement knocks on the door. No one answers. Front door is locked. But there's a sliding glass door that they're able to enter through a porch. And as they enter, it is more and more clear that this is going to be bad. There's a couch just inside the sliding glass door with blood all over it. And the place is just trashed. Garbage all over the floor in the kitchen. Moving into the living room from the kitchen, there's a drop cloth strangely laid out on the floor. And again, trash is lying around. So law enforcement, while announcing themselves, go deeper into the residence, into the hallway that all the bedrooms are off of. They check the first bedroom on the right. A little unkempt, but otherwise normal. Before even opening the next door on the right, they can see, which would be Nick's bedroom, they can see the fluid pooling at the bottom of the doorway. Open the door, and there's Nick, covered with a tarp. Also, paint poured on parts of him. The room is just a disaster. Paint spattered on the walls, egg on the walls, garbage just piled on the bed in the middle, trashed. Down to the next bedroom, the last room on the hall, the master bedroom. Door opens, and there's Richard, partially rolled up in a rug, covered in paint, as if someone had just poured some paint on him, onto his face. Beyond him, into the master bathroom, is Laura, kind of rolled up in a carpet, a red towel on top of her back, some paint poured on her, and the rooms are just ransacked, trashed. Paint flung around on the walls, stuff piled on the bed, just like in Nick's room, drawers emptied, completely trashed. And all three occupants long dead. So now the investigation begins. A search warrant is obtained to search the residence. Initially, at first check, the identities of the bodies were not obvious, especially Nick. And with the investigation, especially one of this magnitude, a lot begins to happen at once. The medical examiner is going to have to come, collect the bodies, to do the autopsies, figure out what it was that killed these people. The scene is going to have to be searched and processed for evidence to try and figure out what happened to these people, who may have done this to these people. Anyone who could have or could lead to information, law enforcement is going to try and seek out and speak to. So on the scene, various areas of blood spatter are found and documented. Interestingly, several areas of blood spatter on the walls have been painted over with white spray paint. But multiple receipts and similar items are found from the December 14th of 2018 and later. Domino's pizza boxes, McDonald's receipts, notably a receipt from GameStop dated December 16th and a receipt from Home Depot dated December 18th. A white Krylon spray paint can is found in a box of trash on the porch. And in the washer of the laundry room is found a shirt with the Punisher logo on it and some shorts that appear to have either paint splatter or some sort of chemical like bleach or something splatter on them. Fingerprints are attempted from all kinds of different objects, all kinds of different places within this residence. Ultimately, a hammer is located underneath the master bedroom bed. That hammer will eventually be tested for DNA, and it will match its last victim, Nick. This defendant's fingerprints end up being found all over the place. Jewelry box in the master bedroom, on that Krylon white spray paint can, on a package for masks. I say masks, I'm going to call them COVID masks. But remember, back in December 2018, nobody had heard of COVID. Nobody had even heard of a COVID mask. We all learned about that in 2020. But those things were still sold, still available, and there was a package for them with this defendant's fingerprint on it. There are also some things that should be there that were not. Most notably, Laura's red 2013 Kia vehicle is nowhere to be found. The only vehicle there is Richard's, a van belonging to Richard that was really Nick's, that Nick would use. Nick and Richard's IDs are not located. There's some personal items that are missing that are expected to be there. Richard was a coin collector. All the coin collection's gone. There's a revolver that should be there that's gone. Now, I told you multiple things are going on at the same time. One of the things that develops is that Jamie and this defendant are two people that law enforcement want to get in touch with, if for no other reason than for notification of what has happened and basic information. Eventually that shifts to wanting to locate the two of them and their kids because no one is sure exactly where they are or where they even should be. Later in the investigation, Jamie's gray Hyundai vehicle is located at the clubhouse parking lot of the mobile home park, which is roughly a couple hundred yards away from 1954 Juanita Way. The trunk is stuffed with multiple trash bags full of things that clearly came from 1954 Juanita Way. paperwork that would have been in Richard and Laura's bedroom, Laura's and Jamie's passports, some receipts indicating that the defendant had been in Texas until at least December 2nd of 2018. In the garbage bag, some receipts from Laura's probably last shopping trip on December 14th. There's a pillow saturated in blood. And also Laura's purse, which we know had gone on that December 14th shopping trip with her, and that also has blood on it. So major focus swiftly becomes finding this defendant, finding Laura's red 2013 Kia vehicle. With the help of law enforcement in Ohio, on January 3rd, 2019, Laura's 2013 red Kia vehicle is discovered at 1573 Newman Avenue in Lakewood, Ohio. And one of the people staying at that address at that time was this defendant. So Detective Anderson and Detective Scarpati with Tarpon Springs Police Department travel to Ohio. The 2013 red Kia is eventually searched, and more receipts are found. Walmart, McDonald's, and more, spanning dates since December 16th of 2018. 1573 Newman Avenue is searched, and a wallet with Richard and Nick's driver's license is located. Also, their credit cards, Richard's coin collection is found, some other items of interest, and also notably a weight belt. Through all the receipts that are collected from the various places that they were found, detectives are able to see that on December 16th of 2018, this defendant went to Walmart in Palm Harbor wearing the shirt with that Punisher logo that was found in the washer, and he buys a bunch of scented scented things which were also found in the house. He goes to McDonald's that day, gets chicken nuggets at lunchtime. He goes and sells a bunch of Nick's video games wearing the same Punisher shirt at GameStop in Palm Harbor in the evening hours. And then he eats at dinner time at McDonald's, again, getting chicken McNuggets. On December 17th of 2018, in the evening, he's at McDonald's again getting chicken McNuggets. December 18th of 2018, the defendant spends the late morning hours going to Walmart in Port Richey, where he purchases that Krylon white spray paint, as well as the COVID masks. Also, some additional items to include clothes that he will later be seen in. He goes to McDonald's that day around lunchtime and gets, surprise, chicken nuggets. And then he goes to Home Depot in Port Richey. At Home Depot, he buys tarps, which are found in the residence. One of them laid out. One of them appears to be on Nick. He buys a paint can opener, which is found in the residence. And also on the Home Depot surveillance, you can observe that he is wearing blue shoes, and I'm going to call them unblemished blue shoes. On December 20th of 2018, he goes to Dunkin' Donuts and Holiday. On December 21st, 2018, around lunchtime, he gets chicken nuggets from McDonald's in Port Richey. He then goes to Walmart in Hudson, where notably those blue shoes that were unblemished a couple days earlier now can be seen with paint or bleach splotches on them, consistent with the paint and the chemicals that were poured on the bodies. The defendant orders Domino's Pizza that evening at 1954 Juanita Way, so that would be the 21st, where he is still staying. On December 22nd, he goes to the McDonald's in Port Richey in the evening. And then on December 23rd of 2018, he leaves 1954 Juanita Way for good. And he leaves, and we track him out of town. He stops at a McDonald's on State Route 54 in Pasco County in Newport Richey at about 2:30 p.m. And then we next pick him up in Macon, Georgia, at a McDonald's in the evening hours on his way to Ohio. And every time we were able to see the defendant and see the vehicle that he is using at any of those locations, it is the defendant driving that 2013 red Kia vehicle. Laura's 2013 red Kia vehicle. And then sometime Christmas Eve or Christmas, the defendant is in Ohio until he is caught on January 3rd. Defendant has, detectives get different records, different communications the defendant makes, and they reveal some of his activities, what he was planning to do as all this is playing out. As I told you, Ohio authorities picked up the defendant, and Detective Anderson and Detective Scarpati flew up to Ohio as quickly as they could. Detective Anderson ends up sitting down with this defendant, and the defendant confesses. Chillingly, heartlessly, methodically, he describes his version of what he did and to some degree why he did it. One thing he says, though, that no one knew yet, although some had been starting to suspect and likely would have been discovered soon after, is about Jamie. Remember the defendant's wife, Jamie Ivancic, who he lived with at 10930 Norwood Avenue in Port Richey. Way back in January, February of 2018, well, it turns out that Jamie never moved away from Norwood Avenue. The defendant had killed her. According to the defendant, during an argument that turned violent, Jamie had armed herself with a knife. The defendant had disarmed her and then strangled her. And while she was helpless, he bashed her head in with a hammer. At least 12 separate blows, caving in both sides of her head. The defendant had then left her body in the bathtub for a few days while he figured out what to do. In that residence, he had a fenced-in backyard, so some privacy. He dug a hole about 3 feet deep, put Jamie in trash bags, and buried her in that backyard. He then trashed that residence to distract from his crime, pouring paint or other liquids all around the bathroom where her body had been bleeding out, messed the place up, and he and his kids abandoned it. Fleeing first to Ohio and then later to Texas. And since then, the property manager had renovated the residence, rented it out again, and no one had yet thought to excavate the backyard looking for Jamie, who was, as of yet, no one had realized was missing. Because the defendant had then pretended to be Jamie on her phone, texting people, responding to texts, hiding the fact that Jamie was dead and buried in the backyard in Port Richey. It was a plan that was to some degree successful. That continued to be successful until January of 2019. But Jamie's parents had wanted to see her. They wanted to talk to her. They kept trying to communicate with her. And the defendant was afraid that his crime would be discovered. So he decided that he was going to travel from Texas to Tarpon Springs and kill them. He planned to kill them, to take their stuff, and to do the same thing with them that he had apparently succeeded with Jamie. So when he arrives at 1954 Juanita Way, without Jamie, it had nothing to do with Jamie having been at work or creditors trying to reach them. It was because she had been dead and buried for 10 months. He arrived to execute his plan that would help him avoid arrest and avoid the consequences of his actions. And execute it, he did. I expect the evidence to show that days before starting his Tarpon Springs murder spree, he was planning on taking Laura's car and going back to Ohio. He waited until he could safely crush their skulls with a hammer, one at a time, when he's alone with Richard. I say alone because the two children were very small, but while he was alone with Richard, on December 14th, latest December 15th, he bashes his head in. He describes how he had to go back over and finish the job because initially he thought Richard was dead, but turned out he wasn't. Defendant patiently waits for Laura to return and then bashes her head in with a hammer. He then moves their bodies to the master bathroom, cleaned so that Nick won't realize that his parents are both dead in that trailer when he arrives. And of course, the defendant likes Nick. Nick's his friend. Doesn't like him enough not to violently murder him, but likes him enough to hang out with him for probably maybe the entirety of December 15th. And then when Nick is asleep, he swings the hammer at him. Again, Nick was jolted awake, and in the defendant's words, I think the defendant's words are jolted awake, but the defendant is unrelenting, continues to bash Nick's head in for another 6 or 7 times by his own count, until Nick is sufficiently incapacitated, and then he drags Nick's body into the bedroom. So then there's phase 2 of the plan. Remember, bashing Jamie's head in with a hammer and burying her in the yard, trashing the place, worked so well the last time. So the defendant begins the process of burying the bodies in the yard at 1954 Juanita Way and of messing up the crime scene. In so doing, he moves the couches around. He moves the couch that Nick was killed on into a different room to block off the entryway. He goes out to buy that Krylon spray paint. He uses that to spray paint on the walls to try and hide the blood spatter. He gets the tarps from Home Depot, and he gets rope at Home Depot so that he can wrap the bodies up and drag them out to bury them in the yard. He pours paint and chemicals on the bodies to try to help with the smell. He starts digging the hole. But sometime around the afternoon of December 18th or on December 19th, he has to change the plan. He realizes that Richard is too heavy for him to get to the hole, and that he may not have the ability to get the 3 bodies from the house into the yard during the cover of night and into the hole that he has been digging. He still messes up the house, but now his plan changes to he's going to leave the bodies where they are. He's going to go back to Ohio. He's going to work out, exercise, bulk up. Remember that weight belt I told you about? And in the meantime, perhaps the bodies will get lighter as they decompose. And then the defendant will return sometime around February, complete the plan, and bury the bodies. He uses Laura's phone to send messages to her family members, just like he did with Jamie. So on December 23rd of 2018, when he leaves 1954 Juanita Way, leaves the decomposing bodies of Richard, Laura, and Nick en route to Ohio. He does so to enjoy the remainder of the 3 weeks that he had bought himself for the price of violently ending 3 lives. Now, that's not all the evidence that I expect you'll hear over the next few weeks. Over the course of the next few days, Mr. Doga and I will be presenting evidence to give the general circumstances of the crime, but also to prove 4 different aggravators with respect to each of the 3 murders. 1, that the defendant has been convicted of another capital felony or violent felony. And since the defendant sits before you, having already pled guilty, he has been convicted of manslaughter for killing Jamie, which satisfies that aggravator, and also for each other murder he's been convicted of. 2, that the defendant committed the offense to avoid arrest. That in murdering Richard, the defendant was trying to avoid the arrest for killing Jamie. That in murdering Laura, the defendant was trying to avoid arrest for killing Jamie and Richard. And that in killing Nick, he was trying to avoid arrest for killing Jamie, Laura, and Richard. Three, that the way the defendant committed each murder was cold, calculated, and premeditated, based on the plan he made and the manner in which he set out to destroy the remaining members of this family. And four, that the murder of Richard and Nicholas was especially heinous, atrocious, and cruel. And then, the conclusion of the evidence, we will ask you to weigh those aggravating factors against any mitigation that may be presented, and then find that the aggravating factors outweigh the mitigation, and that this defendant should be put to death by the state of Florida. Thank you.
Thank you, Mr. Sarabia. Ms. Oliva, you may proceed with your opening statement.
Judge, I will reserve my opening statement.
All right, thank you. State, please call your first witness.
State would call James Quinlan.
Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do. Please wait, please, sir. Please watch your step. Thank you. Actually, speaking to the microphone, loud, clear tone of voice for the court, please. Thank you.
Good afternoon, sir.
Thank you.
Ms. Stoic, you may inquire. You may.
Good afternoon, sir.
Good afternoon.
Could you please state your name and spell it for the record?
My name is James Michael Quinlan, and it's Quinlan.
And where are you employed?
I retired on July 4th.
Where were you employed prior to that?
Prior to that, I worked for the State Attorney's Office as an investigator.
And as an investigator with the State Attorney's Office, is that a position where you would be a sworn law enforcement officer?
Yes, I have been. I've been a sworn law enforcement officer for 40 years this year. Back in 1985, I went to the academy, was sworn in. I have a bachelor's degree in business with a minor in finance. And prior to becoming a law enforcement officer, I was also Air Force military intelligence.
What sort of training did you get to become a law enforcement officer?
The basic academy training, but in my entire career, most of my career I spent as an investigator, and I've probably been to every school imaginable except for a canine school to be a canine officer. I've done all kinds of narcotic, homicide, burglary investigations, economic crime investigations, hundreds.
And were you working in that capacity as an investigator when actually, let me take a step back for a second. Were you called to assist in an investigation on January, I believe it's January 2nd of 2019?
January 1st.
January 1st, okay.
Yes, sir.
So you were there
2019.
So was that the first day of that investigation?
For me, it was, yes, sir.
How did you become involved in that? How were you called?
So at that time, my role since probably 2014 with the State Attorney's Office was that I was a liaison to law enforcement for like homicide cases and grand jury cases and that kind of stuff. they actually had an investigator who was assigned to assist Tarpon Springs Police, which is a smaller police agency here in Pinellas County, and they were unable to reach him, so they called me that morning and asked me if I could assist in the case. They would probably have a need for a prosecutor and a judge for a warrant.
Okay. And were you able to provide that assistance?
Yes, I was.
Okay. Did you actually go out to the scene to
Yes, I
participate in
did.
that?
I spent probably 10 or 12 hours at the scene on January 1st, 2019.
And did they ask you to do anything else to assist with that investigation?
That day, nothing else was done. I was only a tool utilized to facilitate a prosecutor and a judge.
Okay.
And after that day, I agreed to help them out. And I would go in the morning and do my work here, I had to do in the morning, and then go to Tarpon Springs Police. And they had a to-do list. It was a list of leads and things they had to get done. It's a smaller agency. It's very small. Police department, small CID unit. And so I would take things off that list and go do them for them in the daytime.
Can you explain to the jury what a CID unit is?
So CID is Central Investigations Division. It's usually people who are assigned preliminary to work on specific crimes like burglaries, homicides, rapes, narcotic investigations, and that kind of stuff. Tarpon Springs Police has a smaller CID unit than most agencies in Pinellas County, and that's why we used to provide an investigator to them who was not available the day they called for help.
And did you assist in performing tasks on each of the days that you went out to the agency?
I did, yes sir, I did.
Okay. Do you recall going to the agency on January 3rd?
Yes, I was out there that day working.
What sort of tasks did they need help with that day?
So that day, it was more like when you go into their office, their CID section, there was a list of things they had to get done. I just took the next thing up on the list and I do, and that day I was asked, I chose to go show several photo packs.
Okay. Now, the jury may not be familiar with what a photo pack is, so can you explain what that is and sort of how they're done?
Yeah, it's a tool to use analytically to provide investigators information to maybe validate the witness's credibility. Just because you saw a crime, potentially you might not be a good witness, so to say, like you can't identify the person or details of the crime. So we use that photo pack to help narrow down and validate the veracity of the witness to make sure they really did see what they said they saw.
Okay. And so you said you got 3 photo packs and went and administered them to different people?
Yes, I did that day. Yes, sir, I did.
Okay. Now, at that time, did you have any idea who the suspect was?
I knew who his name was, but let me tell you a little bit about photo packs and how it's done anyways, all right? So I've done hundreds of photo packs in my life. I've been the preparer and I've been the facilitator on photo packs. And so the way it's been done probably the past 15 years at least is that the person who shows the photo pack has no idea what's inside the photo pack. And the photo pack is laid out with 5 people who resemble the suspect, potentially, but they look the same characteristics, but there's actually a page put between each photograph, so it's a point in time the person's brain can be cleared. You're not going from photograph to photograph to photograph, and they might get distracted by, well, now I'm getting confused. So the photo packs were prepared by somebody else, and I agreed to go administer them, and I did so. And that photo pack, each one I showed, had 5 potential people along with the suspect.
Okay. And at that time, did you have any idea what the suspect actually looked like yourself?
I knew a little bit about it, but I wouldn't know the photo pack because when I take it out, it's a blank canvas. I take it out of the envelope, and as I bring it in, I've not done the arrangement of the photographs. I don't put them in like 1, 2, 3, 4, 5, 6. That's done by somebody else, which they did that day. So my job was just to show the photo pack, the 5 people with the suspect, with a cleansing page, so to say, between each photograph.
And was one of those photo packs that you administered that day administered with a woman named Debbie Lafferton?
Yes, it was. Lived at 520 Cary Lane.
Okay. And was she able to make an identification with the photo pack you showed her?
Yes, she was.
Your Honor, may I approach the witness with what's been marked as States 1 for identification?
You may.
Mr.
Quinlan, do you recognize that?
I recognize my handwriting in front of it. Yes, I do.
And what is that?
It's evidence. It's been opened and sealed by somebody else along the way, but this is a evidence package that you seal up your package you've done the photo pack in.
Now, you mentioned that you recognized your handwriting on the front of it?
Yes, I do. In fact, you ask them a series of questions to make sure they clearly understand how important it is not to guess. You can't say you're 80% sure that's the person or you're 70% sure. It's either you know the person or you don't know the person. And I go through and clarify that with them ahead of time to make sure that when they do pick somebody, that's the person they believe it to be. Now, of course, sometimes a person may know about the crime or the inference of the crime, but they really can't identify that person. They'll say, I can't pick him out or pick her out, whatever it might be, which is very normal. In fact, it happens more often than not.
And Mr. Quinlan, can you open that package up and take a look at that photo pack?
Yes?
Can you just flip through, just make sure that it's everything that's supposed to be there is there?
If this is what I sealed up originally, it'd be the 5 people that resemble the suspect, and then, of course, the suspect picture. And yes, the one page here that was, Ms. Lafferton said this was the suspect that looked at the person that did the crime.
How did she mark that on that page?
She might have marked something else. What I have here is my own handwriting on this page right here.
Okay.
It was at 5:36 p.m. on January 3rd. And they're people who all resemble potential
Your Honor,
suspects.
we would stipulate to the admission of this.
All right, so it's admitted into evidence, State's Exhibit number 1, I would assume?
Yes, Your Honor.
All right, very good.
I bring it to the clerk, Your Honor.
You may.
Your Honor, may I publish the page that the detective indicated?
You may.
Right. Page number 4. I might also like to say is that the pages that separate that are not included in that pack today,
Okay.
the blank pages.
Did Ms. Lafferton indicate what she was identifying him as doing? That identification.
She had told me that he was seen at the residence.
For the record, I'm showing page 4 from State's 1 to the jury this time.
Mr. Quinlan, did you assist with any other activities with the Tarpon Springs Police Department at that time?
Trying to assist Tarpon Springs Police with a timeline, they had a large bag of mail that was retrieved from the victim's mailbox. And I agreed to go through that bag of mail and sort of like sort out what was in the bag of mail and to see what the furthest back postmark was in that mail.
Can you explain what the importance of that would be?
Well, trying to define a timeline, when potentially something was mailed and when they last checked their mailbox. And going through the mail I looked at, the oldest postmark was December 13th of 2018. Which sort of more like made Tarpon Springs Police aware of the fact that the crime happened somewhere after 2013, but before January 1st of 2019.
Just for clarification, do you mean sometime after December 13th?
That's correct, yeah, 'cause it was postmarked that day. Usually it wouldn't come till the very next day, potentially, but, right.
Thank you. I don't have any additional questions at this time, Your Honor.
Thank you. Any cross-examination?
No questions, thank you so
All right.
much.
Thank you, sir. You may step down.
Am I excused, Your Honor?
You are.
Thank you.
State, please call your next witness.
Your Honor, at this time, the state will call Deborah Lapperton. She's the one that'll be on Zoom.
All right, so we're going out of order a little bit. All right, so I thought she was going fourth, but that's all right. So we'll take a break, and then we'll try to set up this Zoom, because no matter what sort of preparation you do, there's always an IT issue, okay, no matter what. All right, so we'll go ahead and we'll give you a brief 10-minute break. Hopefully we'll be ready by then, okay? Thank you. All right, you may be seated. All right, everyone's here, including the state and the defense and the defendant. All right, no one really asked for the rule of sequestration to be invoked, and I've been told that somebody called Court TV, who's a witness, and said, can I watch the rest of the trial on Court TV? So anyone asking for the rule to be invoked, or under the circumstances, that's not necessary?
We're not asking for the rule to be invoked.
You're not asking?
No.
Okay. Thank you. All right, so Ms. Laverton, can you hear me? All right, and for some reason, I can't hear you. I don't know if that's because I don't see where you have your audio turned off. I don't think you do.
Mine's on.
All right, there you go. Okay. Okay, so I turned up the volume there.
Okay, thank you.
I'm just getting so good at this. Okay, so are we ready to bring the jury back in? We are. All right. Oh, all right. I left my water in the witness room. Oh, well. All right. Welcome back, members of the jury. State, please call your next witness.
Thank you, Your Honor. This time the state calls Debbie Lafferty.
Good afternoon, ma'am.
Hello.
You may inquire. Mr. Dilley? Oh, yeah. All right, ma'am, please raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
Very good. All right, you may inquire.
Thank you, Judge. Ma'am, can you please state your first and last name and spell it for the record?
Deborah Lafferton, DeBeralaffferton.
Ma'am, are you currently retired?
Yes,
And how long have you been retired?
since April 18th of 2025.
And what did you do before that?
I'm an RN, and I was working from home, from my home in Tarpon Springs at 520 Cary Lane. I was working, doing utilization review for HCA Corporation.
About how long did you do that?
7 years.
Okay. And so, did you start doing that in 2018 then?
Yes, July 2nd, 2018.
And where do you
I've
reside?
been a nurse for 45 years, but I'm sorry.
No, no problem. Where do you currently reside?
Currently, I'm living in Oshkosh, Wisconsin,
And how long have you lived there?
since April 27th of this year, 2025.
And where did you live before that?
520 Cary Lane, Tarpon Springs.
And did you live at that Tarpon Springs address in December 2018?
Yes, I did.
How long did you live at that address total?
I moved in May of 2018, so, I don't know, 7 months. May, June, July, August.
Do you recall the people who lived on the corner near the mailboxes in your neighborhood at 1954 Juanita Way?
Yes,
How did you know them?
They had purchased the house and they had moved in, not quite sure when, I know it was 2018 probably. And she had a pair of kissing Dutch people statues, and I had asked her when she was out in her yard if I could have those, and then she said yes, and so I gave them Christmas cookies, and she and I met at the mailbox and talked briefly. So I knew them in passing.
Okay. Did you see her around the neighborhood fairly often?
Really just going to the mailbox. She and her husband weren't much for the pool or being out and about, walking their dogs. I did see her walking the dogs.
Okay. Now, did there come a time in December of 2018 where you stopped seeing her walk the dogs?
Yes, as far as an exact date, it was just before Christmas. I know that.
Would it be fair to say that it was sometime around the middle of the month?
Yes.
Did you ever see her out and about with her grandchildren that month?
Yes, she had, I think I was told that they were 3 years old and 2 years old, and her grandchildren were visiting, and they would walk with her, walking the dogs.
Now, after the point came where you stopped seeing her out and about walking the dogs, did you ever see her out of her residence at any point after that?
No.
Did you ever see anybody else in the vicinity of the residence after you stopped seeing her?
Yes, there was a young man outside the residence on 2 occasions. I saw him and he was doing what looked like landscaping, but he was digging a trench, and it was about 3 to 4 feet deep, and at the time I saw him, it was at least 6 feet long.
Did that strike you as odd?
Yes. I remember telling my friend in Wisconsin that there's some guy digging what appears to be a grave outside of this house, but I said, it's just odd that he's out there digging this trench.
So is that what it looked like to you then?
It looked like a grave, yeah. I mean, the dimensions, to me, look like a grave.
Had you ever seen that man in the neighborhood prior to when you saw him out digging the grave?
No.
Was anybody with him when he was digging the grave?
His children were outside with him. I was walking my dogs, and they started to run over because they wanted to pet the puppies, and I had to tell him to not have his kids approach my dogs because they weren't used to children.
Were you concerned with what might happen?
Yeah,
Now, after you saw the man a couple times in front of that residence digging the hole, did you ever see anybody else in front of that residence afterwards?
No.
Now, did there come a time that the police came out to the residence and there was quite a commotion there?
Yeah, that was January 1st of 2019.
What do you remember
In the
about that?
afternoon, they were putting up crime scene tape.
Okay. Did the police ever come speak to you about what you might have seen?
Yes, during the first couple weeks of January, there was a meeting at the clubhouse by the police, and the detectives asked if you had seen anything, no matter how small, please come forward. So I talked to the detective, and then they did send a detective to my house to take my statement.
Okay. And did you tell them what you had seen at that time?
Yes.
Did they subsequently send an investigator out named James Quinlan to show you what was called a photo pack?
Yes.
Were you able to take a look at that photo pack at that time?
Yes, he showed them to me one at a time.
And when you looked at that photo pack, did you identify the person you had seen digging that grave in front of the residence in that photo pack?
Yes.
Thank you, ma'am. I don't have any additional questions at this time.
Thank you. Any cross-examination?
One moment.
Okay. Appreciate it.
Thank you.
All right. State, please call your next witness.
I'm safe to call Don Ivancic.
Good afternoon, ma'am. This way, please. Step up and hold this. Stand right here. Face the clerk. Raise your right hand. Receive the oath.
Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
This way, please, ma'am. Please watch this step, okay? Three steps up. Now, as you're speaking to that microphone, loud, clear tone of voice for the court, please, all right? Thank you. Thank you, ma'am.
Good afternoon, ma'am. Mr. Doig, you may inquire. Yeah, have you sworn her in yet?
Yes.
Yes. Okay, that's okay. Sometimes you just can't swear enough.
Good afternoon, ma'am. Could you please state your name and spell it for the record? Could you spell it?
Pardon?
Could you spell your name for us?
Spell it?
Yes, ma'am.
Godsey.
Thank you. Ma'am, are you currently retired?
Yes.
How long have you been retired?
Well, over 20 years.
And where do you reside?
Pardon?
Where do you live, ma'am?
Target.
Tarpon. What neighborhood?
In the Meadows. It's called the Meadows Mobile Park.
And is that a retirement community?
I'm sorry, I can't.
Is that a retirement community?
Say what?
A retirement community?
Yeah.
Okay. Or a 55-plus community, I
Right.
guess I should say.
Right.
Did you live in that neighborhood in December of 2018?
Yes.
How active are you in your neighborhood?
At the time I wasn't real active, I was traveling a lot.
try to keep in touch with them, speak to them, and things of that nature?
Yes.
In fact, when this case got set for trial and subpoenas went out, did you actually go check on your neighbors to see if they got subpoenas?
Yes.
Okay. So you try to keep on top of things, it seems, right? And have you always more or less been that way?
And I what?
Have you always been that way, that sort of neighbor?
Well, yeah. I mean, 'cause all the neighbors around me are the ones that pretty much knew everything going on.
Do you recall the people that lived on the corner near the mailboxes at 1954 Juanita Way?
Mm-hmm. Yes.
Did you know the people that lived there?
Briefly. I don't think they've been there too long.
Can you tell us what you did know about them or how you knew them?
Well, the husband, I saw him, I never really talked to him, and the lady, I had talked to her maybe twice. So I saw her walking her dog some, but that's about all.
Okay. About how old did they seem to you?
I think he looked like he was in his 70s and she was maybe 10 years younger.
And you said you saw her out and about the neighborhood a little more than him?
Yes.
Did you ever speak with her?
Twice.
Did you speak with her at all in December of 2018?
Yeah, it was around then.
Did she say anything about what was going on in her life at the time?
No.
Okay. Now, did you ever see her around the neighborhood beyond, say, about a week before Christmas of 2018?
I don't remember, but not that I can recall.
Okay. Had you seen her walking the dogs fairly regularly before that?
Yeah, off and on. I'd see her just out from my door, you know.
Now, later in the month, did you see anybody else near the residence that you had not seen before?
Yes.
Can you tell us about that?
There was a man, and he was actually digging a trench the length of her sidewalk. He was outside digging.
Okay. How deep did it look to you?
It looked like it was getting pretty deep.
Did that strike you as unusual?
Well, yeah. I mean, don't know why he was digging it.
Did you ever speak to him or ask him what was going on?
Well, I was going to the mailbox and I waved at him and said hi, and he did the same thing. That was it.
Was anybody with the man when he was digging that
No.
trench? Now, eventually, there ended up being police out in the neighborhood to look into what had happened at 1954 Juanita Way. Were you in the neighborhood when that all happened?
No, because after the 18th, probably like maybe the 21st or so, I went out of town to my son's house for Christmas, so I wasn't there. I didn't know what had happened at all.
Did law enforcement reach out to you?
Yes,
And did you talk to them about what you had seen?
on the phone, yeah.
I don't have any additional questions this time. Thank you, ma'am.
Thank you.
No questions, thank you.
All right. Thank you, ma'am. You may step down.
Done, thank you.
You're done. All right. State, please call your next witness.
State would call Richard Ivancic.
Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Good afternoon, sir. Mr. Sorby, you may inquire.
Judge, could you please introduce yourself to the jury?
Yes, my name is Richard Ivancic Jr. Richard Lewis Ivancic Jr. It's Ivancic last name. I'm the oldest son.
All right, well, we're gonna get there. Mr. Ivancic, how old are you?
I'm 59 years old.
And you don't have to give me the exact address, but what area do you live in?
I live in West Palm Beach, Florida, the other side of the state.
And how long have you been down there?
Over 30 years.
Yeah, well, I want to ask you about some people. Did you know someone else by the name of Richard Ivancic?
Yes, my father.
Okay. And do you know his date of birth?
Yes, December 13th, 1947.
Okay, now, whereabouts were you born? What area of the country?
Cleveland, Ohio.
And what's your mother's name? First name?
Janet.
Now, your mother, Janet, was she married to your father?
She was. They were high school sweethearts.
And where did you all live when you were young?
West side of Cleveland, pretty much all over the west side of Cleveland.
Ohio people?
Ohio people.
It's all Ohio to me.
Very good Midwestern people.
And do you have any brothers with the same mother, Janet?
Yes.
Or any sisters?
My one is here today, Mark, my youngest brother. Mike is the third oldest, and then my sister Renee is here today as well. There's actually 4 of us within a matter of 6 years.
Okay.
So very close in age.
So who, do you know Laura Ivancic?
Yes.
Who is she to you?
I knew her.
Who is she to you?
My dad's second wife.
Okay. And when did she come into your life?
About a year after I graduated high school in 1985.
Okay. And obviously by then your father was divorced. And did he marry Laura?
Yes.
And while they were together, through the 80s, 90s, what area of the country could we approach?
You know,
All right, you may. You may continue.
Thank you, Judge. So, Laura and your father were living in Ohio. While they were in Ohio, were they fostering children?
Yes. Yes.
And through fostering children, did they eventually adopt 2 children?
Yes.
And do you know their names?
Jamie and Nick. Nicholas and Jamie.
So, I guess, what would that make their Nicholas and Jamie's relationship to you be?
They were ours, not by blood, but by age. They call brothers and sisters, I guess you can call to us, but they weren't by blood.
Okay.
Stop.
Now, at some point, did your father move down near you?
Yes, he did.
And was that in the few years prior to his death?
Yes, it was.
And roughly what area of the state did he move into?
I lived on the west side, or the east coast of Florida. Near me is Lake Worth, Florida. The mobile home there. I was waiting for Laura to come down, and I don't know if it's as expensive here as it is in West Palm, but it's a little expensive over there, so we decided to move from West Palm to this side of the state.
So when he moved down, did Laura move down with him?
No, he did not. No, she did because she was taking care of her mom.
Okay. And did her mom backing up a little bit, did Nick also move to Florida and live with Rich during a period of time?
Yes, he felt it was better to join his dad because of employment opportunities.
Okay. And were you aware, did your father and Laura and Nick at some point move to 1954 Juanita Way in Tarpon Springs?
Yes, yes.
Was that roughly middle of 2018?
Roughly, yes.
Had you been to that residence ever before all this happened?
Yes, I had. I was there once before, or shortly after they moved in. I couldn't help them move because I travel a lot, so they had moved in and he wanted me to come over and see it. I happened to be there at a cigar event, so I popped in.
Okay.
I mean, Tampa, popped in to see it. It's a nice community.
All right.
Exactly what you need.
Let me ask you this. In terms of Laura and Richard, did they keep a clean house or did they leave stuff lying around all over the place?
It's funny you ask me that. My dad is very anal retentive. Okay? He's an engineer, or he was an engineer, so he likes things very organized, very neat, very tidy.
Okay. So would it be unusual to see receipts and things lying around the house, trash on the floor, or
Absolutely.
walls messed up,
Absolutely.
couches across doorways?
Very unusual.
Okay. So would you talk to your father on the phone, text with him, those types of things?
Yes.
Every now and then see him?
At least every week or so, we check in. I would probably call him or text him if I was traveling to a unique location because he likes cigars as well. I would share cigars with him. I'm in that business, so that's how we connected at a later age.
Okay. Do you recall his 71st birthday,
I did.
December 13th of 2018? Did you have any contact with him on that day?
I did call him. I called him on 13th to wish him happy birthday. I think it was later in the day. I think it was during the week. I think I might have been traveling before the holidays. And we were kidding or joking because he was excited that his grandkids were coming. I have two kids myself that are about the same age as his two kids. Two girls, they live out of state. And I was traveling to see them for Christmas. So we were sort of joking about that on his birthday.
Okay. And you were going to visit your children who recently had grandchildren?
Yes. It was my first and only granddaughter. It was the first Christmas, so I wanted to be there for Christmas. So
And were you talking to your father about that because this would have been his great grandchild?
I was, and he would comment back that he was going to have his grandkids come and visit too, with Jamie and the defendant.
Now, in that discussion, did you discuss that when you got to North Carolina, South Carolina?
South Carolina.
South Carolina, that you would be communicating with him and sending him photographs and things of that nature because of the
He
occasion?
loved receiving pictures, especially like I said, I travel a lot. I send him pictures of a lot of places I go to. So he wanted to see some pictures of his great grandchildren, which were good.
And when you would send him photographs and things like that, would he normally say something about it?
I would always see some kind of response. It could be a like on the picture, it could be, something about the picture. I would always see some kind of response, yes.
So would it be unusual if you sent him photographs of the new great-grandchild and did get no response?
Very unusual, yes.
Okay. So that birthday, December 13th, 2018, was that the last time you talked or saw your father? Or had any contact with him at all?
It was absolutely.
So obviously, at that point in December, you're going up to visit family, about to be the holiday season. Were there multiple times between then and New Year's that you were sending him photographs?
Yes. Yes.
And did you get any responses after that? Did it get to the point where you were concerned?
Yes.
Did you try to call him?
I did.
And did you get any response?
None whatsoever.
Was that unusual?
Yes.
So, as time goes on, is there come a point, December 31st, where you're traveling back?
It's about 10 hours from South Carolina back to West Palm. I had plenty of time on my hands to talk. So, after I tried reaching out to him, no answer. I don't remember if I tried texting Laura or not. I don't remember. But I know that was the end of that day. I got home and I went to bed and woke up the next morning and said, something's just not seeming right. Okay? I have a lot of friends in law enforcement, and I know what a welfare check is.
All right, now let me ask you this. So now you've compared notes. Are you concerned?
Very concerned, yes.
Now, you know what a welfare check is. Have you ever called in a welfare check before?
No, never.
Is that something that you just like, hey, I haven't talked to somebody, I think I'm going to call the police and have them check?
No, I talked to a couple of friends of mine, just to say, what can I do? I mean, besides driving over here, which is 4 miles away, it'll be fine. They suggested do a welfare check. I thought about it, I said, that's a good idea.
Okay. So when did you place that call?
Tuesday.
So January 1st of 2019? Okay. And when you called, were you put in contact with Harvard Springs Police Department?
Yes.
And did you provide them some information and why you were calling and why they were going to end up going out to 1954 Winnetka Way?
Yes, they were. I gave them the address, told them what my concern was about the picture, not getting back from them. The officer said he would call me on the way there, and she did. When I hadn't heard anything for quite some time, I became very concerned.
Okay.
Yeah. Something had happened.
Was there in having the officer go out and do the welfare check, were you hoping to hear back from the officer pretty quickly?
Yeah, it was.
And in fact, did you get upset when you hadn't heard from him in hours?
Yes.
And then did you try to get more information about why hadn't you heard?
Well, yes, I did.
Okay.
I didn't have any information back, so I know quite a few people in this side of the state. She called a bunch of friends and asked them to go up. One of them called me back and told me they.
Say, Your Honor.
Sustained.
So, eventually, did you get in contact with law enforcement?
I did.
And at that point, did they give you some of the information about what had happened?
Yes.
Judge Bainbone?
You may.
Couple questions for you. Was Nicholas also living at 1954 when you went to them? And there was a van there. Was that the vehicle that Nicholas generally would drive?
Yeah, it was in my dad's name, I believe, but he was driving because Laura didn't share the car. He had it was stolen.
Okay. Did there come a point around January 4th-ish where after law enforcement, and maybe 4th, maybe 5th, after law enforcement had been in the house and done the investigation, that you had an opportunity to go in the house?
I did.
Now, and did you see the state of the house? Is that the way that your father would have, and your stepmom would have kept the house?
Something I don't know.
I don't have any more questions.
Thank you. Any cross-examination?
No, you don't.
All right. All right, Mr. Sarabia, would you like to present anything else?
Yes, Judge. Mr. Ivancic would like to present something to the tax case.
All right. Hang on a second, okay. Members of the jury, you are about to hear evidence about the impact of this murder on the family, friends, and community of Richard Ivancic, Laura Ivancic, and Nicholas Ivancic. This evidence will be presented to show the victims' uniqueness as individuals and the resulting loss by the deaths of Richard Ivancic, Laura Ivancic, and Nicholas Ivancic. However, you may not consider this evidence as an aggravating factor. Sir, you may proceed.
Thank you. Thank you. Sorry to wear glasses because I'm getting old. I'm here representing myself and my family. I do not need you attendance today. I'd like to read my written statement to verbally express our feelings and discuss the impact this crime has had on me, personally, and my family. I'm speaking to you as the oldest biological son of Richard Ivancic Sr. It was very hard to try and put into a few words a life of memories. My father, and a bit later, would just say, school quarterback, and her mom was the captain of the cheerleading squad at West Tech High School in Cleveland. He was quite an athlete. He had offers to play for college ball, that is until they had me. During his senior year in high school in 1965 and 1966. They were raising 4 kids by the age of 24 and were married for 14 years. But, of course, as they were childhood sweethearts, known each other since 7th grade, so just about over 20 years. After the divorce, my father spent some time searching for what he wanted to do with his life. Since graduating high school, Dad had worked his way up the ladder to CI, which is Cleveland Electrical and Mini, and retired as a draftsman in the engineering department. After meeting his second wife, Laura, they decided to start a family. Unfortunately, after having 4 kids, due to the previous medical procedure, my father was unable to see additional children at this point in his life. This led them to the path of foster parenting. Dad and Laura were foster parents for many years to many, many children when they lived in North Burlington, Ohio. While they fostered many kids from various broken homes and families, his biological kids all lived in different states. We tried to keep in touch with him, get texts, phone calls, occasional visits to town to celebrate a holiday or birthday. Dad and Laura moved to Columbus, Ohio, after he retired, where he started a business called Powerline Accessories with a partner of his. They were what you call a modern-day storm chasers that would send power crews to areas impacted by major disasters, like hurricanes that we have in Florida. In fact, many of us in the courtroom may have been impacted by our father's work to restore power during some of the recent hurricanes during the 2007-17 timeframe. In 2017, he sold his shares of Powerline Accessories. During this time, Powerline, he enjoyed boys trips with his brothers, Ken, John, and Bob, along with some close friends. And on occasion, he would invite the young guys. We would join him, including myself, my cousin Jimmy, or brother-in-law, Doug. I'm sorry. We would have a great time bonding with boys, playing golf, visiting local horse tracks or casinos, just simply enjoying life. It wasn't until they met and cared for Nick and Jamie that they decided that these were the 2 kids they wanted to adopt and raise as their own. Nick and Jamie were very young. I believe around the age of 5 and 8. I could be wrong. Both Nick and Jamie came from very challenging and unstable families. Laura and my dad changed all of that. They quickly became the children that they could not have themselves. They gave them everything they could possibly want or need growing up. Yes, they were quite spoiled. Even after retiring, they took care of Laura's parents in the later years, as well as caring for Nick and Jamie during this time. My dad and Laura loved foster kids that they cared for and were torn every time they had to give them up. They were innocent and loving parents and grandparents that had many more years in front of them. In fact, I was driving back from visiting my kids and granddaughter in South Carolina. I shared pictures of a trip with Dad and Laura, but never would have guessed that this was going to be the last time I talked to them. We will never get to see them again and can only hold on to the memories that we shared along the journey of life before they were all taken away by him. Thank you.
Anything else regarding this witness? Any cross-examination? Thank you, sir. You may step back.
Thank you.
Take your time. Please watch your steps. Any further witnesses for today? You may. going to have today, so we're going to stop for the day a little bit early, which is not bad news. It's obviously been a long day. I do have a motion calendar in the morning with various other cases on the motion calendar. However, Judge Susan St. John has graciously volunteered to handle that for me, so she'll be handling that while we can start early. We really want to make sure that we get this done. Done even a little bit early. So if you can be back tomorrow at 8:45, so we'll have a full day of evidence and testimony tomorrow. I believe that I can tell you where to meet. It'll be anything about the case, you already know all of that. Everyone has a juror badge. Don't forget to have your juror badge on in the morning. If it was me, if I brought it in the house, I would probably forget it, so I might want to leave it in the car, or if you have a purse, keep it in your purse so you don't forget it. And then have it on as you come in, because when people see that you have that on, that tells everyone not to say anything to you that they shouldn't say, or say anything about the case or anything like that. All right, anybody have any questions or anything? So we'll be done by 5 tomorrow. If we can stop a little bit early, that'll be great, since we're going to start fairly early. So I will see you back here at 8:45, okay? Thank you. Okay. All right. State. Okay. When you're driving and people say it takes a good hour. I don't know what the difference is between an hour and a good hour, but I guess a good hour is truly more than an hour. So we're going to take a short 10-minute break, and then we'll talk about any issues we're going to have tomorrow. So we're not going to talk about every single issue that we have remaining in the case, just what we need to know about tomorrow, okay? All right, we'll see you in 10 minutes. All right, you may be seated. All right, if I can make a comment about any future victim impact evidence. I thought what we just heard on the stand is... All right, let's bring him out. All right, so Mr. Nealy is here now. Everyone's here. All right, as far as future victim impact evidence, I thought what we just heard on the stand is the way things really should go. I thought, at least on the stand, he was very poised and very professional, and I thought he did a really good job. And I'll also add that what I heard is what I think is the intent of what should be presented during victim impact evidence. So I'm not saying that to pat ourselves on the back, but if we are, that's okay. But I'm really saying it because that's what we need. We don't need anything that obviously we're not allowed to do according to the U.S. Supreme Court and the Florida Supreme Court. All right, so what other issues are we going to have tomorrow? I know there's going to be a lot of ID texts and photographs and that sort of thing, so I don't know what issues we would have tomorrow.
Judge, there's some photos that the state plans on introducing. By and large, there's no objection to them. With the exception of, at least from what I understand they're introducing tomorrow, they have lots of photos from the home that show different areas of the home in complete disarray, things thrown, things, paint everywhere, that sort of thing. Which I understand, why those are being admitted into evidence. But then out of nowhere in those pictures is just a still picture of Jamie and Nick on a wall. There's no blood, there's no nothing, there's no evidentiary purpose for that. It's just when they were little, they were, like a little brother and sister picture together. And there's really no reason to have that.
All right, so I assume that when you're presenting mitigation, you're not going to have a picture of the defendant when he was 4 years old with a baseball cap on and that sort of thing?
Well, yes, Judge.
Oh, okay.
Have photos.
All right. All right, what
But
says...
that's different than, that's like victim impact.
Mhm.
That's not,
Right.
this isn't, that's
All
strung
right.
throughout all of their disarray photos.
All right, what says the state?
I apologize, I'm trying to find the photograph that they're talking about. I believe that was his bedroom, and there was one clean wall. So there was 3 walls that were obvious, and part of it is just some of the laziness of the defendant's efforts, but the weightiness of this room is he appears to have stood in a particular spot and flung paint all around and didn't get anything on the wall behind him because the body was there. So there was a completely clean wall. And it just so happens that wall has a picture of Jamie and Nick on it.
All right, why is there any evidentiary value? I understand how there's evidentiary value with all the spatter and things thrown all over the other walls, but why does it matter that there's nothing on that wall?
Because it shows it's not that the entire house was trashed by some unknown people or unknown group just trashed everywhere. It was a deliberate trashing done with a plan. It's like if you walk along the beach and you see a word spelled out, you know somebody put that there. This shows that somebody obviously did this with intent to disrupt the privacy.
All right.
Well, we have
All right, can I
not
see the
disputed
photograph?
that.
Hmm?
We have not disputed that.
Mm-hmm.
All that said, I'm not terribly upset about the photo, but that was the purpose.
Yeah, I'll grant the defense motion. I mean, this photo is really big, and these kids look really cute, so I think a 403 analysis is that the probative value is outweighed by the prejudice. I don't think there's a whole lot of evidentiary value there. Obviously, you can get all the other photographs in of all the other walls that were tampered with. I guess we can use the word tampered with. Or desecrated? Well, that's not a good word either.
And then, Judge, there were maybe 6 to 8, I'm trying to remember, 6 to 8 photos from the autopsy that the state used during their perpetuation of Dr. Ignacio's depo. And while I don't dispute that one for each might be appropriate, they're a little bit gruesome and gross, and we've heard descriptions of them, and I don't think we need that many.
All right, well, I mean, the case law is rather clear. If they're gruesome, then they're still admissible as long as they're relevant. The issue is not gruesomeness, it's irrelevancy.
Well, but I don't think we need that many, is my point also.
All right, so how many photos do we have of each the victim? Now, I've heard there's a whole lot of hammer strikes with at least a couple of these victims. So if you have more than one photo, as long as it's showing different injuries, then it would be admissible.
And Judge, I'll pull now would be a good time to go over that. I'll pull all the photos I believe that we have of the bodies.
Okay.
Because there's one other witness early tomorrow that would introduce other ones. All the ones in the medical examiner, though, were selected specifically because it was the only way that we could accurately explain the injuries.
Okay. Did she indicate that in the deposition to perpetuate testimony that all of the photographs were needed for her to explain the injuries to the jury?
Well,
If those weren't her exact words, it was, do the photographs assist you in explaining exactly what the injuries were?
that was asked at the very end of the
Okay, well, it doesn't matter when it's asked. I mean, the issue is if it was asked and if it was answered, so. But I can take a look at it.
And so, these are the ones from the medical examiner right now, right? All the photographs that we would ask to admit from the medical examiner's testimony have her initials and the date on the back. All these. So this folder is Nick.
Okay.
This folder is Richard,
Okay.
and this is Laura.
Okay. All right. All right, do we want to go in alleged chronological order, or?
I think Nick would be the easiest one, that's one photograph.
Okay. So that's it. You have one photograph of Nick's injuries. That's it.
Correct.
Okay, well, I mean, we can't,
For the medical examiner,
right. Right, well, we can't say that's cumulative, right? So, and then all the blood is all gone. I mean, this is a photograph after everything is all cleaned up and we just see the damage to the skull. Is that what that is? State. Anybody from the state?
I'm sorry.
What this is a photograph after everything is all cleaned up. There's no blood or anything, and it's a photograph of his skull with the damage to the skull. Is that correct?
Correct.
All right, so I don't see any problem with this at all. I mean, it really couldn't have been done any better as far as the picking which photograph to use, so there's no,
that one had one, I forget which ones had one and which one had multiple.
okay.
Laura had two, she's probably the next.
All right, so Laura's next. 1, 2, 3, 4, 5, all right, so, and again, this is, oh, no, that's got to be Nicholas.
No, that's Richard.
Oh, that's Richard, sorry, okay. That's right, we just did Nicholas, sorry. All right, so this is Richard. Again, it's after he's all cleaned up. And it looks like there's...
The first one's at the crime scene, I believe, with where you can see the 2 injuries on his chest.
Right, and it looks...
Versus that one.
It looks like the shape of a hammer, too.
Correct.
Right, okay, so nothing wrong with that one. Is this a close-up of the injury on the chest?
Yes, that's the neck.
Okay, that's the neck. Okay, so that's a whole different injury than what we can see in the first photograph. Then we've got his face. Again, no blood and things cleaned up, but everything's pretty dark. I guess that's just from decomposition.
Correct.
All right, and that's the face, so that's not the chest and not the neck. That's the face with obvious injuries to the face or the forehead. And I guess the eye too, right?
Correct.
Okay. And then we have what looks like a hammer mark, but I can't really tell where.
Sorry. That is, one of those is the back of his head, one of them is the... And again, part of the reason for this is we tried to pick pictures that were close, that would not be obvious, that would be as possible. This one is the back of his head.
Okay.
And this one, I believe, is the upper right temple area.
All right. So these are all different photographs of different injuries. I mean, obviously, if he had we shot him once in the head, we might have had one photograph in the front and one photograph in the back, the exit and the entrance. But we have a whole lot of injuries here, so there's like one photograph for one area. So it's not cumulative at all, and it's after he's all cleaned up, as opposed to having blood all over and all that. So I don't see any issue with these at all. All right, so they're coming in. All right, then we've got Laura, right? 2, okay, so, and it looks like the skull, there's a lot of damage to this skull, and there's different areas of the skull with injuries. I can't really tell what's the front and what's the back, but one of them, there's a whole bunch of injuries. I don't know if that's the back, and then...
Yeah, one of them is from the back of her head. You can see all the injuries and damaged skull. The other one is after the scalp has been reflected, peeled back, and you can see the crack of the skull on
Right.
the other side of the head.
Right. All right. So I don't see any issue with this. Now, how many total photographs were taken? Because it seems like sometimes the judge has to do all the work to make sure that only the photographs that are appropriate come in. And sometimes the state can just do it on their own. And it seems like you just did it on your own. So how many photographs were taken? There's probably hundreds?
70 to 120 per victim.
All right. Yeah, and now we have a total of 8, something like that?
Total, yes.
Okay. All right. I don't see anything wrong with any of these. They're all relevant. They all show where the injuries are. And they're all in different spots of the body that were injured. So I don't have an objection to that.
Judge, while we're on that topic, I did one of the witnesses tomorrow, not medical examiner, the bodies at the crime scene. I'm sorry. You have?
Okay, I don't have those, I don't think.
So this is Nick covered by the tarp.
All right, and there's no dog in there, right?
Correct. None of the photographs have the dog.
Okay.
This is Nick underneath the tarp, which shows the paint and that things were done before the tarp was placed there. And
Okay.
this is Richard as found. This
Okay.
is Richard once the carpet has been removed, and you can see all the paint.
Okay.
And this is Laura. You can't even tell that there's a body there necessarily, but that's Laura in the carpet.
Yeah.
And this is once they unroll the carpet, you cannot see any of the dogs.
Yeah. Yeah, and it's a little bit hard to tell that there's any bodies at all. I mean, you see mostly tarps, and then you see, I guess, what could be bodies, but it's not really evident, and then a bunch of paint. So I don't think these things are cumulative at all. I mean, you have 3 different victims, and you have them in the tarp, and then you have the tarp uncovering them with a bunch of paint on them. So did you guys have any objection to these?
No,
Okay.
as long as they're not used to argue any kind of hack or anything like that. Conditions of the body, what was done afterwards.
Right, I mean, if they're dead and you put paint on them, I mean, that's not gonna be hack, right? All right, so any other issues?
A redaction, Judge, of the judgments and sentences, because it's got the last 3 counts on there.
Oh,
It was our intention to admit the judgment and sentence in order to prove the aggravator because he'd been convicted of 3 murders in this case.
I don't know if the court wants to just read a stipulation.
why don't we just read a stipulation, okay?
If the defense is willing to stipulate that the defendant was convicted, we are.
Okay. All right, so I'll just read the 3 counts of the indictment again, and then just say that there's a stipulation that the defendant did enter a guilty plea and was convicted of those. All right. All right. What about the manslaughter? Are you going to get that in?
We have the judgment and sentence for that.
Okay.
I just need to make sure none of the other papers, there's nothing on the other pages.
Okay. Are you going to get that in?
Would it make more sense to stipulate to both, so there it's not that lingering question about why do we have this and not?
But that's fine. That's fine. And then if you want to put the dates on when he was convicted, that because I don't know when they were, I don't even remember when it was on this case. So
That's fine. However you want to do it, it's fine.
I have no problem with the stipulation, but I would kind of like to have the one physical document because it is a different situation, different case.
We can have a separate stipulation, how about that? That way, it just makes it, that way you don't have the question about why don't we have the 3.
Would you be willing to stipulate that it satisfies that aggravator?
That's fine.
Okay.
all right. So yeah.
So, no, I mean, Judge, okay, so, first of all, I objected to that based on the Aka case, the Johnson case, that's void for vagueness and shouldn't even be considered here. So because of that objection, I get it, that if we're looking at it, just looking at it like, oh yeah, it satisfies this aggravator, it's a prior capital, or it's a prior felony involving, violence, I guess, which I say is vague, or the contemporaneous one satisfy. I mean, I understand that, and he can argue that, and it's not like, I'm not gonna argue vagueness to the jury.
Okay.
So it's not like
So
the arguments are gonna be vague.
so his question, Mr. Brunbarn said yes, but he got overruled. So your answer is no. All right. So if you want to do a stipulation, there's a standard stipulation language, but then you have to say what it is you're stipulating to. Are we going to do this tomorrow, by the way, or some other day?
Your Honor, I think I may have persuaded lead counsel that there is a way around it. That we could stipulate to the manslaughter, but still also preserve the legal objection that we had made earlier.
So you're going to stipulate that he was convicted of the manslaughter, but not stipulate that that is an aggravating factor.
Well,
Where are you?
Based on the court's ruling,
Okay.
right? Based on
Yes.
the court's ruling, that's a legal issue that we're not going to be arguing with the jury. I'm not going to stand up in closing and say that that's not an aggravator.
Okay.
That's not going to be my focus.
All right. So what usually happens on stipulations is you guys draft it, you agree to it, and then I read it. So I know there's not a whole lot of agreeing in this case, but can we agree on that? So the guidelines from the court here would be that both parties stipulate that the defendant was convicted of manslaughter in the death of Jamie, I don't know what her last name is, but, oh, no, Ivancic, okay. Jamie Ivancic, and the defendant pled guilty on blankety blank day or something like that. Obviously, it'll be a lot cleaner when you guys do it. And then the defendant pled guilty to killing Richard and Laura and Nicholas on whatever day it was. If you want me to read those three counts in the indictment again, I can do that. I mean, they've already heard it. All right, so you guys figure that out. We're going to make you agree on something besides the fact. All right, awesome. So I don't even know if you guys want that tomorrow.
We were probably going to do it Monday.
Okay, all right. All right, so that gives you a whole weekend to agree. You have each other's emails and texts and everything, so you can email them like at 10 o'clock on Saturday night while they're out watching a movie or something. Okay, so anything else?
Judge, there were 2 phone calls that the state provided to us. The other day, I was able to listen to one of them. The other one I haven't been able to listen to. It's not playing for either of us for some reason, so there may be, are you planning on doing that? So we can have some time.
Are these jail phone calls?
Yes, 2.
Okay. Are they long?
So that might be something I'm just letting the court know. And then, the state indicated that it plans on putting some Facebook messages into evidence, and we are objecting to some of those.
Okay.
These messages in particular are between Mr. Nealy and a female by the name of Summer Colt, who lives in Ohio. Included within these are messages on December the 14th, 2018. And I'd say 5 of those photos are of Mr. Nealy naked, 3 of them with an erect penis. And these are messages with some writing that are going back and forth between the 2. I asked Mr. Sarabia what the relevance of that was, and he said because he had killed them, and then basically this is what he's doing after he kills these people. However, if you listened to the state's opening today, well, first of all, in Mr. Nealy's statement, he says that he did it on the 15th or 16th. Not on the 14th, but the 15th or 16th. And I don't know if they want to have their cake and eat it too, but they want you to believe the rest of Mr. Nealy's statements in that 4-hour-long interview, but not this one. And then today in opening, Mr. Sarabia, I believe I quoted here, 2 days after his 71st birthday, this defendant murdered Richard. So that would, since Richard's birthday is the 13th, that would make this murder on the 15th. And so I don't see really, A, the relevance of those, because it doesn't go to why he told me they were relevant. 2, even if they were on the 15th, even though they're timestamped the 14th, I still don't see the relevance of those. And 3, they're prejudicial, and the prejudice whatsoever. I mean, we don't really need the jurors staring at 2 photographs that are just naked of Mr. Nealy, and then 3 that show an erection. That's non-statutory aggravation at its finest right there, along with the entire conversation. Because some of that conversation is, the female is saying, when are you bringing my 2 babies up here? And of course we know the babies belong to Jamie. And so that's just nothing other than to try to inflame the passions of these jurors and make that a non-statutory aggravating factor.
All right, so after he kills these 3 people, he's sending those photographs. It was before?
No.
It was either immediately before or immediately after.
If I can lay it out for you, because 1,
one, that's not what I said in opening. I did give a time frame. I said the day after, or at most 2 days after. But it is our position that this defendant, despite what he may have said, because he got a lot of dates wrong, he also said that he left the house on the 22nd until the 23rd, that he killed Richard and Laura on the 14th, as all the evidence seems to indicate that. These messages start, there's several sets of messages. In fact, there are 2 sets of messages with Summer Cole. This set of messages that defense counsel is referring to begin with a conversation about the kids, where the defendant on the 14th at around 10:20, which would seem to be before he killed anybody, is talking to this woman with the intent of going up there and sends pictures of his kids in the crime scene. I say the crime scene, I mean the residence where all this happened. Locations that are demonstrably present in the crime scene, showing that they are there. And to the extent that you can see them, it looks clean. He then
Well, if we can get that in without also having photographs of erect penises, I think that would be good.
I'm building that.
Okay,
That's
all
where
right.
we start. There is then a break between about 10, 12, a couple of messages. Back and forth, actually, I got this. So then, there is a gap of time between roughly 10, 11 a.m. and these are 5 hours. The timestamp is in Universal Time Code, so it's 5 hours ahead, which is roughly at, and then we have a break, which our position is he's killing the victims at 12, 11, and again, I don't think. So on the 14th at, I'm doing math right now, 5:30, the defendant says, yes, ma'am, it was time for the other one to go. I'm sorry. The conversation starts out 12:14 at about 5:20. Daddy works out, honey, plus car shopping was today. And I'm actually starting in the middle of the conversation because we're talking about him being tired. Yeah, I'm sorry, Judge. Let me back up. Because there's lots of things back and forth, and they all have relevance for one reason or another, because there's delays in the communication. At 4:20, the defendant says, I meant I'll hold you, LOL, my bad, daddy's tired. Why, the person says, why are you so sleepy? The defendant responds, he responds an hour later. So now we're at 5:19 p.m. on the 14th. Daddy works out, honey, plus car shopping was today. He says, and the kids were little rascals. The person he's talking to 6 minutes later says, you've got a new car, ? And he responds 7 minutes after that, yes, ma'am, it was time for the other one to go. I traded it in for a 2013 Kia SUV thing, which is the car that he takes from the victim.
Right.
More room, better vehicle, I'll still get good mileage too. The conversation goes on a little bit. But so that particular message is extremely important because we believe that shows Laura is dead at that point. So Richard and Laura are dead because he now has a new 2013 Kia, which he will now maintain all the way until he's captured. Even if it's not, it shows a plan that he will have a 2013 Kia very shortly. But either way, Laura would have gotten home around 4 o'clock. He says he killed Laura right after she got home. At 4:20, he's texting or messaging somebody that he has a new Kia, that he's been car shopping. At 5:20, that he has a new Kia vehicle. I think that is extremely probative and goes to the motive of the case. So then he proceeds to send a series of photographs, him taking a picture of himself in the mirror.
the same day, and he gets one in return. And about 6:23 on the same day. So again, short time period, which would have been before Nicholas was killed, but after Laura was killed. And it shows him, it's the only photos we have of him in the crime scene. It's the only photos we have of him in close proximity that he is sending utilizing this Facebook account. So it shows that he is in fact the one who is sending these messages, because the name he uses is Shelby Rose, not Shelby Nealy, not Shelby Svensson. We know that Shelby Rose is an alias of his. So while he is committing these series of offenses, death, sending pictures of himself masturbating, murder, I think that's extremely relevant. I think it goes into the facts of the case. I think that it shows that he's at the crime scene. I think that it shows he's sending all of these messages and many others talking about how he's going to get a vehicle on December 11th, how he's going to get a vehicle. I think he tells his mother he's going to get a vehicle. He tells his mother on the 12th that he's still in Texas, clearly planning to avoid any attachment or knowledge that he's in Florida. And then, in between killing people, he's masturbating and sending photos of it to his girlfriend.
All right,
And
all right, I understand.
I'm sure you're familiar with the Merck case where the Florida Supreme Court has found that a similar statement about how that defendant was feeling in the midst of committing the crime was relevant. It was not excluded. And I know the Merck case has come back many times on other grounds. I'm sure Your Honor is very familiar.
It's come back a lot of times, yes.
But not for that. So
Right.
So, Judge, I'm not disputing those statements about I have a car and that sort of thing. But when he says, and now these two are dead, and we know that it's at this time, and we think it's before 12 or whatever, well, the only place he's getting any of that is from my client's statements. There's really nowhere else that he's getting that type of specific information from. They might have been trying to build some sort of timeline and that sort of thing, and most of their timeline went to dates. But the stuff that's on there regarding, what are you going to do with that penis, and penis pictures, and then her breast pictures, and all that, and the part of the dialogue that's, when are you going to bring my two babies up here? Like, that's it for no reason. We're not disputing that these are Facebook messages that he engaged in. In fact, we told the state, no, you don't need to bring in your Facebook people or your records custodian people or whoever to authenticate any of this. So,
Okay.
we short-circuited all that, but those...
Okay, so there's not going to be a witness who's going to testify about this. You just subpoenaed it from Facebook and, all right. All right, let me take a look. I hate to say that, but let me take a look.
Just don't forget that there's also writings in there about like things that are irrelevant to, not about a car, not about whatever, about...
Right.
Well, this is the conversation between these two people.
All right.
Between the 14th and I
Yeah.
think
Yeah, I mean, this is what I'm thinking right now before I look. The condition of the house before these murders is irrelevant. That should come in. The Kia evidence should come in. We can also have a stipulation that he was sending photographs at certain dates and certain times. You don't necessarily need to have the actual photographs in. I mean, I think there is a 403 issue with that. Were you planning on getting these in tomorrow?
No.
Okay. Next week? Right.
We were going to go over with the detective.
Yeah, I mean, I think you can probably put a detective on to say that this was subpoenaed, and then you can ask him if there were photographs that were sent on different days and different times, and you can lead him or her a little bit. All right, so now he's sending photos of his kids.
It goes backwards. So if you start in the back, that's.
Oh, okay, that's the beginning part?
And then it goes forward.
Mm-hmm. So, I take it this is a new girlfriend of his?
You say new 6 months?
Okay. So, after the 10 months,
Yes.
right? All right, well, I don't think we need to get any photographs in, okay? I think that if there's, and I'm not really, all right, I guess the photographs at the end show the condition of that house, right?
Well, the end shows some of the items that he stole
Oh.
from the house at that point. Part
Okay.
of the state's presentation is showing how long he was there before he killed these people, to show
Mm-hmm.
the cold, calculated, and premeditated nature of it.
Mm-hmm.
And also how long he was there afterwards, to show what he was doing to act in accordance with that plan. And also just the circumstances of the crime. And so building that timeline and showing where he was, when he was, what he was doing, what the condition of the house was at various points is important.
All right.
Moreover, his actions in between killing Laura and waiting for Nick to come home so he could bash him in the head and kill him too, I think is extremely relevant, because that goes to cold calculating. What's he doing? He's masturbating and sending photos to his girlfriend. I
Well,
think
how do we
that's-
know that? If it
I think
happened
that
on
that-
maybe the 15th
Well,
or
I
maybe
think
the
the evidence,
14th?
I think the evidence shows, and we will argue that the 14th.
So,
He got the key on the 14th,
Yeah.
his words, not mine.
all right, so, I don't know if masturbating shows cold calculated and the premeditated of the murder, okay? If there's photographs that show what he stole, that's fine. If there's text messages about the Kia, as you've described, I think that's fine. If you want to put the detective on to say that this was subpoenaed and he was sending photographs on these days and these times, I think that's fine. I mean, the nature of the photographs, I don't think is really very irrelevant. I know the state does under Merck. I don't really remember under Merck about anything like this, and I'll independently say I think the prejudice outweighs the probative value on this. So if you want to get into the fact that he's sending photographs, and then if you want to say that they're naked photographs of him and that's it, one question, one yes, that's fine. Okay, but the photographs themselves, I don't think should come in. Okay?
Your Honor, can I ask one question about that?
Yeah.
Part of what's very important about that, at least one of the photos, is it shows that it is in the crime scene. It shows the objects, that where they were found when the police got there. That's one of the things that we were hoping to demonstrate with that picture. Can the detective also talk about?
Yeah, I mean, if the picture is of him masturbating and then also the house looks really clean, then the detective can say, yes, the picture is on Facebook. So I would put a detective on to be able to describe what I'm not allowing to come in, which is the photographs. I just think under 403 analysis, it's just, the probative value gets outweighed by the prejudice on that.
So, Judge, in terms of the conversation, separate from pictures, the conversation that's going on, I'm also arguing that the parts that aren't about a Kia or aren't about the condition of the home or aren't about those sorts of things that are related to coins or the whatever, the conversation, for example, that I was indicating to the court about what are you going to do with that penis or that whatever, what are you going to do
Yeah,
with that? Or what are you going to do
I don't think we
with
need-
that? And also,
I don't think we need any penis conversations.
and when are you bringing my babies up here?
State, is that relevant?
There's a lot of conversations he has with different people, including part of this, where it is clear that his plan is to return to Ohio sometime in mid-December. And he keeps putting it off because he hasn't killed the victims yet. So in terms of his whereabouts and what his plan is and when he's going to do it, is very important.
That could-
all, the whole calculated premeditated is everything he does up until he kills Nick. In my mind, including masturbating. 'Cause
All right.
That's where his head is at. That
All right.
is what he-
Well, yeah, I don't think masturbating is showing calculated and premeditated. But the other stuff, if you can get that in through with the detective and have it nice and sanitized, just what was in there as far as what he observed about that, that's fine. Okay? I don't have a problem with that. All right?
So the pictures of the defendant naked come out.
They're out.
Is there anything else that needs to come out? Because there are pictures of him not naked. There are pictures of the kids. There are, all of that stuff then comes in.
All right, well, what says with the defense about the picture of the kids, for one thing?
And it would have been fantastic if I had pushed on the
Right, I know.
address any of this.
I know. And I think we had like 47 of them, but that wasn't
Exactly what they planned on introducing.
I mean,
All right, well,
I literally gave them all this.
I understand.
Literally.
All right, well, let's not argue about that, okay? Let's just argue about what we have to argue about now.
I mean, like, I'm in the middle of trying to now
I know.
prosecute a case, and now
I know.
it's
I understand.
5:30 on Wednesday. I have a lot of things to do. I still have to cut
Right.
the video. They haven't told me exactly what they want out of it yet, and I don't know when all that's going to happen. And also be able to
Okay.
present all this in front of the jury and understand
All right.
how we're going to prove up
Right.
these aggravators.
I got you. The good thing is, though, I don't think you're going to introduce this until next week, right?
Correct.
All right, so, yeah, I mean, no one's going to have a relaxing weekend to begin with, but, okay.
There are several photographs of the residence, though, that we were going to admit because they depict specific locations, specific items.
All right, well,
that are viewable in those
are-
photographs. So
are-
if they're not coming in, or to what extent they're not coming in.
All right, well, I don't really see any photographs here that show that, to be quite honest with you.
To show what? I'm
To,
sorry.
to show the pristine condition of the house before the murders.
Well, you may not have seen the condition of the photos of the condition of the house after the murders.
All right, so you can have the detective explain that, okay? I mean,
And I'm sorry, but I don't understand the prejudice of photographs of his kids walking around the crime scene.
Yeah, well, that's- I mean-
Whatever the date was, the
all right.
13th, the 14th.
well, that's okay. I'm just, all right, yeah. This picture, for example, the kids are hugging themselves and the house is pristine. That's fine. All right, but as far as the defendant masturbating in front of the mirror, and then you don't really see the house, I mean, you see that the sink looks pretty clean, okay? I mean, that's not coming in under a 403 analysis.
So then,
I don't-
is it the pictures of the defendant naked?
Yes,
Okay.
yes. All right, I mean, that's something that
Then
is going to
I can
disturb and anger
make
this
that
jury.
happen.
Okay, that's not as bad as the dogs, but it's bad.
Right, that's what I was just gonna say, is there's one picture in there of the female showing a little bit of a breast, like that comes out.
Yeah, I mean, that's from
I only
her.
included that for rule of completeness purposes. I didn't want there to be a missing page in the
Right.
records and it
All
not
right.
be clear.
Yeah, so that comes out too, because that's not relevant for anything. Okay, you can have these back.
So,
All right, so the kids hugging, conditions of the house, fine. Anything about the Kia, fine. And then the detective can testify as to when photos were sent, what day and what time, and the state's allowed to get into all that. We just don't want to get the actual photographs in, so he can say that the photographs were sent this day, this time, so we can have some evidence as to the premeditation there without getting into prejudicial or overly prejudicial material.
so, Judge, there's two more things.
Mhm.
On Facebook messages. Mr. Sarabia sent 12 attachments, so hopefully for ease for him, I'm gonna refer to them by the attachment number that he sent them to me. In the first attachment, he sent me, this is the attachments he sent me just a few days ago, maybe Monday. Mr. Nealy uses the word Nigga
Is this off of Facebook or something
Yes,
else?
it's in one of the messages, he uses that word, and some people are offended by that word.
Well, yes. All right, or what's this state about that?
Which conversation is that?
This is it's your first attachment, so wherever your first attachment.
Who is the conversation with?
By the way, with the transcripts, then we go over that Monday? So,
Yes, but he's waiting on one answer from me about the first wife.
I think that comes out. I mean, about the domestic violence with the first wife? I thought he said that comes out.
But there's an issue about what we believe is going to come out in the defense's case. So the defense indicated that they agree.
Oh, okay. So you weren't waiting for me, you were waiting for
We
them?
were waiting for the defense.
Okay,
As we have been on many things in this case.
okay. All right, so we'll let them know sooner rather than later, because they do have a lot of work to do with getting things redacted.
I believe,
No, I want to say it was back in May or early June that I brought up the issue of the transcript and made very clear it would be very difficult to redact in the future.
I mean, we can stay here till 10 o'clock at night if he wants to keep, going on. I'm kind of done with that conversation.
We'll see.
Okay.
We'll see.
All right, so the NIGGA, that's what we're looking for now?
It's in the, yes, Bethany Spears. Page. $3,120 and 121. Yeah, it's twice. 320, 3,120, 3,121. I think that's it. I'm not even confirmed. No, oh wait, it's 3 times. Yeah, sorry. And 3,138. Yeah, I'm looking at the Facebook.
The one on 320, I have no problem with. It's actually the spillover from a previous conversation, not the one that we're interested in. I'm sorry, what's the next one?
The next one is 3,121.
3121?
Mm-hmm.
3121, I don't.
It's towards the bottom of the page.
We're not including that page. 3121, we are not including.
You know what?
We're not including that.
Oh, okay.
Yeah, and
And then 138.
31, sorry.
3. Hold on. $3,138.
That's a different conversation.
It's in the same PDF document.
No, I don't have 3138.
Well,
Is that Bethany Spears?
yeah.
So we are, and to the court,
It's in
we
the-
took, there was probably 12,700 pages of Facebook records. We took excerpts from that almost 13,000 pages to present. So I don't, the page that you're talking about, I don't think is one that we have.
Okay, it's one that it came from your email the other day.
Yeah, that just might have been
I don't have
Not
that
intended.
one.
we tried to divide some of the records into conversations, so we
Okay.
did not necessarily print out all of them. Okay.
All right, so the NIGGA
timestamp of the issue?
issue is no longer an issue, correct?
Oh, yeah, it's in September. Yeah.
Okay, it's no longer an issue. All right, so,
Yeah, that one won't be a problem.
all right.
All right, and then I was trying to understand the relevance of. Let's see.
something you put for all the world to see. All I'm saying is if you're not willing to swing at me, then I don't know if I can date you. If you can't defend your point of view to the point of physically attacking me, then what's the point?
Okay, and then the attachment just previous to that, this is the last one, I think. I believe this is with Abby. I believe this is with Abby Fisher. Let me make sure it's the right one.
All right, is any of this on the record, or are you guys just having a conversation?
Yeah, you have, Judge, there's a section in here that said, mentioned something about Hitler, so I wanted that to come out. I'm trying to see where that is.
All right, well, why don't you work on that
Yeah, it's in the
tonight
first
on your
page.
own time, and then this isn't coming until next week, so if you want to bring this up tomorrow, you can, unless you have it right now.
Abby Fisher, it's 2 pages long.
4583.
And I will we can argue about that.
Judge, do we want to argue about this last one now?
All right, is that the last one?
It's the, yes, I'm gonna go back and I am gonna look at these again, but I looked at them the other night and this is the last one.
Okay, this is the last one for tonight. Okay, so what is this one?
Judge, this is a conversation with somebody by the name of Abby Fisher, and Mr. Nealy says, "I'm in full Hitler dad mode with 2 toddlers, LOL." And I just don't like the use of Hitler. It was used at some point during jury selection as well.
No, it was never used during jury selection. I just mentioned it up here at the bench, and the jurors didn't hear any of that. So I think we were talking about the Callaway case and about hypotheticals and about how you can't ask, what if it's Adolf Hitler and he killed 8 million Jews and 30 million people during World War II? Are you telling me you couldn't vote for the death penalty? That's how that came up. So it didn't come up in.
That's for those exact reasons I want this taken out of here.
Well, it's a phrase. It's not good. The defendant said it, right?
But that doesn't mean that it's relevant and it comes in. It's not like, oh, this is a confession or an admission against his interest or something like that. What's the relevance of, I'm in full Hitler dad mode with 2 toddlers?
Well, I mean, it shows he's having kind of a frustrated day, right? So,
And that in particular, I think that was on the 20th when he is in the crime, I'm sorry, that's on the 19th at 3 p.m., 3:10 p.m. When he is actively cleaning up the crime scene, so.
yeah, I mean, I don't have a huge problem with that. I mean, the people can say that and it not mean a whole lot. So, I don't have a problem with that. If the state wants to take it out, obviously I have no objection to that. If you want to take out the Hitler mode thing. All right, so that's it for tonight. All right, so.
The only other thing we didn't, I know it's late, but the only thing that we haven't gotten to as far as legal issues that could impact tomorrow is the number of victim impact statements. I know we're gonna have.
Yeah, I mean, I have to make a limit here. I mean, I do, because the case law that I brought up before was, hey, the judge has to limit these things. It can't be repetitive, it can't be overly cumulative. So, now I know there's 3 victims here, so on a normal case, I would allow 3, but then do you allow 9, 3 per victim? Well, not really, because people are talking about the same victims at once, you know what I'm saying? So,
Address a couple things.
yeah, all right, go ahead.
So, it is 3 victims, but it's also the victim impact is different perspectives of how that victim impacted that person.
Mhm.
And I think that in that way, the statements that we have, and obviously, we're kind of walking through each statement individually.
Right.
The prior statements themselves, and we did a lot of work with them, with the family, to ensure that they were not repetitive. They're not talking about the same things. They are very different perspectives on the deceased. I wanted to put on a couple of things. I'm sure that the court is aware, because the court's very well versed in the case law related to death penalty issues. But while we do have to ensure that it's not repetitive, there is no specific number that just becomes repetitive by nature. I pulled a few cases last night so that I could address them on the record and at least make a record of it. But I want to start with the Farina case, Farina v. State, 801 Southern 2nd, 44, Florida Supreme Court, 2001. It was not error to admit 12 victim impact statements with a single victim because they were not repetitive. They were not covering the same issue. In the DeParvine v. State case, 995 Southern 2nd, 351, Florida Supreme Court, 2008. That is a case where the state presented 5 victim impact witnesses total, 3 representing one victim, 2 representing a second victim in that case. And in Alcaguer v. State, which was Florida Supreme Court 2021, that was 3 counts of first-degree murder. The state presented 10 victim impact statements in that case, 4 for the first victim, 2 for the second, 4 for the third. The victim impact statements that we have in our case are not significantly lengthy, and they do not cover the same issues. So we feel that additional victim impact statements are warranted and should be allowed in the case. As the court mentioned earlier, referring to the Cozy case, which was from 2017, that was 3 victim impact statements with a single victim, one of which was 50 minutes long. It was a 30-page long victim impact statement. None of ours are anything close to that, and we don't intend them to be. But the family of Laura, as well as the family of Richard, both have different perspectives that they would like presented to the court on their loved ones who have passed, and we would ask that the court allow more than the 4 that the court had settled on before. I think if we had at least 5, I think we could make that work.
You could live with 5?
I think we could, Judge.
All right. And then, 2, even though Richard and Laura are married, they don't have the same kids, right? So Richard has 4, and I don't know how many Laura had, but she had at least 1, right?
Laura had the 2 adoptive children.
Okay.
But it's brothers and sisters, niece, nephew, that sort of thing. She's got a family. There's one niece that was very close to her, named Sir Lawrence, that wrote a very good victim impact statement.
Okay, all right.
She
So,
very much wants to present that.
so if you can live with 5, I can live with 5. And then we went over the law, what they can't say. They can't say anything about the defendant. They can't say anything about the crime itself. They can't give an opinion as to what they think the sentence ought to be. It's just I mean, they can say nice things about the victims. They can say what impact they had and how it's even affected them. The case law says they can do that. So make sure that's all we have. So you can do a lot of the work instead of me. Yes?
So last night we gave you the people that he's talking
Yeah.
about, like Sarah Lawrence, we gave you highlighted copies.
Yeah.
Come out. The only ones we did not have highlighted copies of were 2 handwritten statements, and I do have highlighted copies of those here with me.
All right. Yeah, like I have the one for Renee here, and then obviously the brutal and senseless murders, I mean, that can't come in, okay? So why don't you police those yourself first, and then if there's any other issues, then I'll deal with it. I mean, you know what can come in and what can't. And, you know, and I understand the frustration, but it's not a sentencing hearing per se that we normally have. It's a death penalty proceeding, and one of the most overused things, but overused because it's so true, is death is different. And they have to make a lot of different findings and a lot of different evaluations. And, I mean, there was one great question by one of the jurors. It's like, well, if we're not supposed to consider this, why are we hearing this? Okay, which is, you know, which is a pretty good question. But obviously, the U.S. Supreme Court said, yes, you can do it, as long as the states allow it, and the state allows it. There's even a statute that allows it. The Florida Supreme Court allows it. So we'll to follow the law, but by including following the law, we're not going to allow something to come in that's not allowed to come in, but we will allow what is allowed to come in. So that's just following the law, okay? So you might want to go over this again. I know you probably clean these up a lot because people really don't know what they can say and what they can't say. I mean, obviously, if it's a sentencing hearing, they think they can say basically all the things that you can't say here. So it's not their fault, okay? And I know you cleaned them up a lot already, but you're gonna have to clean them up again some more, okay? But yeah, I'll allow 5. Okay, what did you want to say?
Judge, the 2 handwritten ones I have, one is by someone named Janet, and the other one is Luann Lawrence, if I could approach.
Okay. All right, so any of these people going on this week? All of them? All the victim impact? Okay, are they set for Friday or for tomorrow?
I think one will be tomorrow. Yeah, and Renee was going to be Friday. Originally, with agreement of the defense, she was going to read the other ones, but since the defense has since decided that they're objecting to Renee reading the other ones, as of yesterday, we're trying to get some of the people who are not physically present in the courtroom to be able to hear by Zoom. So that might have to happen next week.
All right, well, you know, we've even allowed, and the defense is even for it, where the prosecutor can just read what somebody else said.
Right.
All right? All right, do you guys have a problem with that? All right, so that's fine. So, I know, like, it's almost 6 o'clock. You got a lot of things to worry about, right? You have witnesses that may not want to be here, so you have to get them here. You have to figure out the evidence. You have to figure out all this, and then you have to figure out a bunch of redactions, okay? I understand the frustration, all right? If I can help you out with that, I will, like if you want to put them on a different day or whatever. But, if you want to read what other people said and they, you know, and they're not going to be here, that's fine, okay? No one has a problem with that. As far as these other ones, if you want to clean them up a little bit to make sure they're consistent with the law, that's great, and then we'll talk about it before you put them on, right? Okay.
One thing that I think we do need to address sooner than later is the video that Renee would like to play during her victim impact statement.
Right.
We've been speaking with the defense. We've already taken out the audio. We already told them we would take out, I think there's some words at the beginning and some words at the end that we told them we would take out. We need to know if there's anything else they're asking to take out, because we would need to have that being done tomorrow so that it can be used on Friday, because I don't know we would have the ability to do it on Friday, and the witness won't be here after Friday.
All right, that seems reasonable. All right, so the music's not going to be played.
Correct. It's already muted.
All right, the things, the writing is going to be redacted, and then it's a bunch of photos otherwise, right?
Correct.
It's like a photo slideshow.
Right.
I mean,
Like you'd have at a funeral or something like that. Okay.
other than my previous objection to the length, there's nothing else
All
that
right.
has to be.
Well, it's 7 minutes, right? So,
Yes, Your Honor.
all right, so not overly long. It might seem long to the defense while it's being played, but not that long. All right, so is that it for today? Okay, it seems like it is. All right, so we'll see you tomorrow. Mr. Brunbon's going to be ready at 8:51, and the jury is going to be here at 8:45, so we should be ready to go.
If you know Judge Freighton and you want to send him an email.